Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police, who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. Hello. Good morning, good afternoon, good evening, wherever you're coming in from. I hope you are having a good day, a good Thursday. I had to check as I was saying it. So Thursday, this is day 21 of the Karen Reed murder trial. We are still in the prosecution's case in chief, if you can believe it. Just so you guys know, I have been dealing with some internet instability. I keep getting kicked off of our hotel's internet, even though when it's good, it's really good. But for some reason, sometimes it kicks you off. And yesterday, things were so smooth, even though there were a couple patches where it would be, kind of slow, the connection. But other than that, everything was good yesterday. So I'm hoping that continues today. So, I think, right now I'm a little bit grainy. I can see that on YouTube, but hopefully that sort of smooths out and things kind of go a bit more smoothly today rather than what they have been over the last hour as I've been monitoring the internet connection anyway. So, okay, sound is good. You're blurry, says Debbie Faison Cook. Thank you. Let's get some questions really quick before we jump into the testimony. Let's see here, because we've already got some questions here. Let's see here. Okay. Well, first off, and Wings, thank you so much for the super chat. The curious case of the magical butts. It is, right? It definitely is. There's a lot of magical butts in this case. Debbie Faison Cook, we're so kind of you once again. Debbie Faison Cook, one of our awesome mods, also for gifting a membership. So Dissimilate even gifted a membership by Debbie Faison Cook. So welcome back to Bike Club. Very happy to have you here. And I hope you can join us tomorrow for our members only live stream at 10 a.m. East Coast time. Kaz Elson, is it a problem if Lally doesn't call Proctor to testify? Yes, I think so. I really think so. I think that, well, before I finish answering, let me answer this one because it's related. Rebecca Anderson attempt to get Bukhenik to testify on the injuries that they tried not to have to call a medical examiner. Oh wait, sorry. Let me answer that one after this one. Cast Iron Mama. That's the one that I was thinking of. If Proctor does not testify for the prosecution, do you think it increases the chance that the judge will dismiss before the defense case in chief, since he collected and transported so much? It depends entirely on whether or not the prosecution is able to check all of those boxes that would have been checked by Trooper Proctor's testimony through other witnesses. So that's what they definitely seem to be trying to do here as much as possible. We had Trooper O'Hara that was testifying about the search for the pieces and a number of these other things. And then we've got Trooper Bukhenik, who testified yesterday. He's going to be continuing his testimony today. Talking about basically, he was there with Trooper Proctor quite a bit of the way. And so there's going to be a number of questions that he can answer, but can he answer all of the questions that the jury has that have arisen in this case in order for them to adopt the prosecution's theory here? I don't know. One of the questions that came up yesterday is the issue of the evidence that was brought in was collected as early as February 3rd. Some of those pieces of taillight that were collected by Trooper Proctor, and yet they were only brought in on March 14th. So what's the explanation for all of those weeks that the evidence was out there and even collected and wasn't brought in? Where was it? What happened to it? Was it who was looking over this evidence? those are questions that the jury may have now as a result of the cross-examination of Ashley Villier yesterday. So, um, so anyhow, so that is there's a number of questions, and that may be in the end a big problem for the prosecution if they can't get those answers. So Kaz Elson, to kind of take it full circle to answer your question, I think it's a problem. I think it's a problem if they don't have him testify, especially because there's been so much about him, and especially if the defense ends up calling him to answer some of those questions. I think there's an issue there for the prosecution. It looks like they're hiding, especially since every single step of the way, almost with every single bad fact that has come out for the prosecution, has come out on cross-examination, which is not how you want it to happen. You want to have control over that narrative, even over the bad facts. So I would not advise it. So now getting back to Rebecca Anderson, do you think that attempt trying to get you meant Bukhenik, I know it's a joke, to testify on the injuries that they tried not to have to call a medical examiner? Well, there's no way that his testimony can actually replace the medical examiner. There's just no way. Even if they try to have tests about causation, there's just absolutely no way. I mean, even if like he could to a certain extent testify about those things because of his experience, you don't want that. You want, like, the jury is expecting to hear from a coroner. They're going to expect to hear from a medical examiner. They're going to expect to hear from doctors about these injuries. And if they don't hear from doctors about these injuries and what happened, and somebody looking at them in detail, somebody who's trained, someone who has the requisite experience, that's going to be a big issue for the prosecution. So I think, so that is, I mean, yeah, that's a huge issue in my opinion. Let's see here now. Solo cup evidence. I love that name. Question, Legalbytes, is it possible the FBI can keep Proctor from testifying? No, I don't think so. I doubt that. Mr. Baker, Legalbytes, does making the jury sit through a Lally direct examination fall under the statute of torture? No, it does not. Jerry Roth, Legalbytes, how are the recaps coming? Thank you so much for the question for that. So my editor unfortunately got pretty sick, it seems. And so he's been kind of rushing to get those done. He's got the material for both day 19 and day 20. So hopefully those can both come out today. We will see. It's depending on I'm trying not to rush my editor. Obviously, if somebody's sick, I don't want to be harping on them to, get work done if they're not feeling well. I don't want to be that kind of person. But of course, I know that folks want these recaps. So I'm trying to work with, trying to figure out where that's gonna go, what the timeline is gonna be. I'm still trying to figure that out. Hopefully we can get at least one of them out today. But I appreciate your guys' patience on that, so that we can kind of get everything back to speed eventually. You got that other video coming too. And also there's another, well, I actually have to redo that one because there's been an update on it. Did you guys have heard about the suspended license guy that went viral like a week ago now? And I made a video when there was one twist, but now there's been another twist as of yesterday. So there's another video that I'm working on that I have to redo now because there's been another development that just completely changes the story again. So anyway, KBH, thank you so much for the super sticker. Thank you very much for that. Okay. Also, Leandra, thanks for the super chat for a Catalina Cookie Company treat for Baby Buds. Thank you so much. Appreciate that. They have some really good treats in there. So thank you. Definitely going to be looking forward to getting one of those. Bora question. The quality of the vids were so bad on my computer, it was impossible to draw any conclusions on the tail light. Might the vid be much better for the jury that they can actually see a broken or missing one? It's possible. I will say that at the very least, the Ring camera footage from John O'Keefe's driveway, the one that showed when she maybe bumped his car and then went out at like 5 a.m. on January 29th. That one I have seen elsewhere where it was like just straight uploaded to like Court TV, and Court TV showed it. And the quality is about the same. So I don't know if we've lost some quality in the court feed. That's possible. But I don't know. Triker question: did anyone else watch the timestamps during the Sally Port video? There were large skips while Proctor was around the taillights, sometimes 30 plus seconds. I saw one that went from like 44, like 5:44 p.m., like 5:44:01 p.m. And then it skipped to like 5:46:48 p.m. So it's like 2 minutes right there. So yeah, I don't, yeah. There are some questions with that, of course, as well. Whether you think it's a nothing burger or maybe you think it's significant might depend on your perspective. DS question: Legalbytes. If the defense are forced to call Proctor because prosecution doesn't, can they apply for him to be a hostile witness so that they can cross-examine him? Exactly. Daniel Evans question: if defense calls him, do you think they could lay down foundation and keep a limited scope of what is testified? That way cross is very limited for CW. I mean, yes, they could limit it to a certain extent, but there's only so much that you can limit, because they still have to be able to come in. They still like to come in and give context on things. Give me 1 second here also. Okay. Also trying to gather more of these. Okay. All right. We got some more questions coming in. I know we'll get the stream started very soon. Maybe I should have started this live stream earlier because of this. All the questions. I didn't realize so many would be coming in. The Robot 77 yesterday, someone on Reddit did a great job breaking down the taillight, figuring out which piece is that piece Proctor brought in. It was on car in the video at 5 a.m. Is interesting. I wonder what the prosecution's going to do if they've got a similar line of logic going on there. Brittany Chanel, we are almost into July. Sort of, will you stream the Alec Baldwin trial after this trial? Yes, absolutely. The Rubber Duck 77 follow-up. So if this is for sure true and Proctor is proven to have planted evidence, will this be a mistrial? I don't know. I think this is more likely something that's going to go to the weight of the case. And when that's the case, that is something that is going to be decided by the jury, which means it's not going to be dismissed. It's not going to be taken away from the jury to make that decision. Desiree Boula, question: under what parameters is a jury chosen? I've been wondering if they picked people who might have a bias against at all. That is something that they definitely will have asked during the jury selection process. That's definitely something that will be. Also, Karen Greco, I think I missed this one earlier. Thank you so much for becoming a YouTube member. Welcome to Bike Club. Very happy to have you here. Hope you can join us for our members only live stream tomorrow at 10 a.m. East Coast time. But yeah, Desiree Boula, just to sort of make sure I fully answered your question. Yeah, they go through all kinds of questions to include, when alcohol is involved in the case, they're going to ask, like, what are your biases about alcohol? What are your thoughts on alcohol? Do you judge people hard for drinking a lot, regularly, regardless of legality, things like that. That's something that, generally speaking, they're going to be asking about. And I would imagine that they did in this case too. Jerry Roth, why show a video so dark you need a spelunking helmet light to see anything? I don't know. It was so frustrating to see yesterday. Kathleen Kibblehouse, I thought the Sally Port footage was missing according to defense. I thought so too. Yeah, there was a bit that was questionable about that. Or maybe not questionable, but confusing, I suppose, because this may have been produced during trial to the defense. Hello, everyone. Says question for Legalbytes. Sorry, brain is working. The image in the Sally Port yesterday was inverted. Yes, it was mirror imaged. That was my ultimate conclusion post stream, and yeah. Okay, so now we've got more from the Trooper Bukhenik, who is going to be right back up on direct examination here now. And okay, so I apologize that this stream may be a bit grainy on my end. I'm so sorry, guys. I hope that this clears up. But anyway, at least the sound is good. That's most important, right? So we're going to get moving to the actual testimony here. Picking back up again with the direct examination of Trooper Bukhenik. Let's go.
Good morning, sir.
Good morning, sir.
Circle back just to a couple things that from your testimony from yesterday. Going back to the video that you reviewed from both C.F. McCarthy's and the waterfall. In total, from those two videos, how many drinks did you observe the defendant consuming over her time?
The video shows 9 drinks being consumed by the defendant.
And that
I don't know where he got 9, to be honest with you. I don't know where he got 9. I got 7. He said 8 at that point at the Waterfall Bar and Grill when he was talking about that gray blob up in the corner. I couldn't see it. So to me, I see 7. But all right. I don't know where he got 9.
that's between when she arrives at C.F. McCarthy's until the time that she leaves the waterfall. Is that correct?
That is correct.
And if I could turn your attention to the ring videos from 1 Meadows Avenue, Mr. O'Keefe's residence. From the videos that you observed, let me ask you first, as far as, do you know how those...
Also, we're going to go ahead and put this on 1.25 just from the jump. We're already behind, so let's do it.
Cameras work as far as when they turn on and when they turn off?
My understanding is that ring surveillance video is triggered to be recorded through motion. So if the camera detects motion, which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system that retains that footage.
And from your review of those videos, what kind of motion would set those off? Like what kind of things would be recorded from the driveway camera?
Be activity such as a person walking through, bird landing, a vehicle pulling in, individuals, moving around in the driveway, and so forth.
The search warrant that was applied for was any and all videos between January 24th and January 30th, correct?
For one of the search warrants, that's correct, yes.
And with respect to that time frame, what, if any, activity based on information that you had received was not available or was not shown on those ring videos?
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring. There was,
what, if any, other video in addition to that one was not present?
there was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
And what, if any, follow-up or what, if any, inquiry was then done with regard to Ring as far as those types of videos or deletion, or how those videos could not be present?
Correspondence with Ring produced information that...
Sustain.
Let me ask this first. Was there follow-up with Ring in regard to those videos?
Yes, there was.
And was there ever anything produced with regard to those videos or those timeframes from Ring?
No, there was not.
If I could turn your attention over to your time in Dayton, just in reference to subsequent to that later on, what, if anything, did you receive, or what, if anything, did you request, what, if anything, did you receive from the Dayton Police in regard to January 29th, 2022?
I communicated with the Dayton Police Department requesting documentation from their officers' calls for service at our request, and log notes, logs from their dispatching center, as well as any reports that would document their activity if such reports existed.
And did you, what, if any, information did you receive in relation to that?
I received a log note or log printout from their CASM, and I received a report authored by Officer Barrows.
And did you also receive any 911 calls?
Yes.
And who was the party as far as the 911 caller in regard to those 911 calls that you received?
It was Mr. Reed.
And again, just for clarity purposes, that's the defendant's father, is that correct?
That is correct.
And that's from the morning of January 29th, is that also correct?
Correct.
Now, sir, if I could turn your attention to February 3rd, 2022. At some point that morning, where did you go?
In the morning hours of February 3rd, we planned to meet at 34 Fairview Road. Myself, Trooper Proctor, and Trooper DeChico arrived at that location in order to conduct a secondary search of the area as the temperatures were turning and the snow was melting naturally. We decided to do another search for articles that were now, we realized and learned, were missing and could be of evidentiary value and aid in the, in the investigation.
And with respect to going to 34 Fairview Road, what, if any, tools or what, if anything, did you bring with you, the troopers, in regard to conducting that secondary search?
Requested the trooper bring shovels, rakes, anything like gardening items that would help them to dig through the snow and locate any missing items.
And as far as the temperature change that you're talking about, how precipitous a change are we talking about?
The temperatures went above freezing, so the snow did begin to melt, and it was significantly warmer compared to the 18 degrees the night incident.
Now, you mentioned items of evidentiary value that you had learned of and were looking for. What, if any, clothing items, Mr. O'Keefe, were you looking for specifically on February 3rd?
We're specifically looking for Mr. O'Keefe's baseball cap.
And in addition to yourself, Trooper Proctor and Trooper DeChico, who, if anyone else, did you notify? Who, if anyone, from any other unit within the state police responded that day?
We requested the assistance of the Crime Scene Services section of the Massachusetts State Police, and Trooper Evan Brandt us with documentation of the location and the evidence that we were hopefully going to find.
And from those, Trooper Brent arrived and took photographs, is that correct?
That's correct.
And when was it that Trooper Brent arrived in relation to your arrival?
I believe he was already present when we pulled up, but I'm sure to his exact time of arrival.
With regard to that day, what, if anything, in general terms, what, if anything, were you able to locate and where was it, generally speaking?
We located Mr. O'Keefe's baseball hat. We located a drinking straw from a cocktail glass. We located items of plastic, colored plastic, and other shards of colored plastic at the location. All those items were located on the grass portion of the yard near the flagpole at the 4 Fairview Road.
And Your Honor, may I approach?
Yes.
Your Honor, may I have a moment?
Yes.
And Sergeant, I'm going to show you a series of photos, but I'm going to break this up a little bit.
So, Mr. with your back to the doors and the issue, I'm sure they can't hear you.
So, sir, what I'm going to do is I'm going to show you some photographs, a series of them, but I'm going to break them up a little bit just to make it,
Okay, sir.
hopefully, quicker.
I muted the mic because there was like noise going on out on the street. Sorry, guys. Elaine. I'm gonna pause real quick so that I can transfer back to the Wi-Fi. Kicks me off sometimes, and then other Wi-Fi picks up. I paid for, but that's like worse than the hotel Wi-Fi for some reason. So I'm gonna try to get back onto the hotel Wi-Fi. This is a long explanation that doesn't really need to be explained. I'm gonna try to get back on there. Just bear with me if things get disconnected for a minute. Just bear with me, okay? All right. Are we good? I think we might be okay. Hopefully. Let's see here. Okay. All right. Yes, I think we're okay. All right. Let's try this out. Hopefully I don't get kicked off now that I did that. All right. Okay. Let's continue on.
So first I'm going to show you 10 photographs. Ask if you could view those, look up when you're finished.
Yeah, this should be clearer. All right, and we're going to skip through.
Thank you. Do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are photographs documented the items located at 34 Fairview Road on the grass as the snow receded through the melting temperatures that were revealed to be positioned in the grass.
And what's contained in those photographs, is that a fair and accurate portrayal of what you observed on the front lawn area of 34 Fairview Road on February 3rd?
Yes, it is.
You want to make approach?
Yes.
I'm off to introduce you as an exhibit.
Any objection, Mr. Jackson?
No objection.
Okay.
All right. While he reviews, we skip. Oops.
Court's
Sorry.
permission, if I... And Your Honor, with the court's permission, if I could just ask to publish some of these photos.
Yes.
Just one moment, Your Honor.
Sure.
And Ms. Gilman, if I could start with photograph 7659. And Sergeant, do you recognize what's up on the screen, what's now been marked as Exhibit 468?
I do.
And if you could, just for orientation purposes, describe to the jury whereabouts in relation to 34 Fairview Road we are in this picture.
As standing on the street of Fairview Road, we're looking at the left side of the yard. In the top right corner, you can tell that there is a flagpole depicted in that photograph and a telephone switch box that's open on the left side, which is on the border of 34 Fairview Road.
And if I could ask from this photograph, if you know, grass that's visible on the front lawn area of 34 Fairview Road, is that from a natural melting process, or is that from some tools that you and the other troopers brought to assist you in your secondary search?
The reason that grass is exposed is due to processing of the scene and having the snow being moved away from the location, and then natural melting process taking place on top of it. As you can tell, other portions of the yard is covered in snow, and the snow had not, the grass has not revealed itself just yet.
Now, as far as the photographs of various items that were located on this date, February 3rd, the photographs that were they taken as they lay, or were they touched or manipulated in any way prior to the photograph being taken?
The items photographed were discovered as soon as we realized what is being discovered through the digging and excavation process. They were then photographed instantly. Certain items were revealed naturally through the melting process and the snow, no longer concealing those items underneath.
Thank you. Ms. Gilman, can I have photograph 7666? Again, sir, do you recognize what's up on the screen? It's now been marked as Exhibit 470.
I do.
And what do you recognize that as?
That is a clear black and red piece of plastic.
And Ms. Gilman, if I could have photograph 7669. And Sergeant, do you recognize what's now up on the screen as Exhibit 473?
Yes, that is another piece of plastic.
And sort of towards the top middle of the screen, do you recognize what that is?
Yes, that's a fire hydrant from 34 Fairview Road, grass area.
Ms. Gilman, if I could have the next photograph, 4670. For the record, this is Exhibit 474. Do you recognize that, sir?
Yes, sir.
Is that a closer-up image of what was depicted in the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7672. And sir, you recognize what's up on the screen, which has now been marked as exhibit 476.
I do.
And what do you recognize that to be?
Another piece of red taillight plastic.
And lastly, from dispatch, Ms. Gilman, if I could have photograph 7673. Again, sir, do you recognize what's up on the screen, depicted in what's now marked as exhibit 477?
I do.
And what do you recognize that?
That is the fire hydrant and telephone switch box located on the edge of the property line at 34 Fairview Road.
Now, the photographs that I had just placed before you, having had a chance to review those,
I have.
and do you recognize what's depicted in those photographs?
I do.
And what do you recognize those?
The property at 34 Fairview Road, left corner towards the street, capturing the flagpole and the telephone switch box.
May I approach, Ron?
Yes.
Call multi to introduce and admit as the next 10 exhibits.
Okay. Thank you.
Your Honor, with the court's permission, if I could publish a few of the photos from this set.
Okay.
All right, more photos.
Ms. Gilman, if I could have photograph 7681. Sergeant, you recognize what's up on the screen. It has now been marked as exhibit 481.
I do.
If you could describe to the jury what's depicted in this photograph.
A red piece of plastic.
Where?
And Ms. Gilman, if I could have the next one, 7682.
Can you use the pointer to show us where that is, please?
Thank
Yes,
you.
Your Honor.
Otherwise, I feel like I'm trying to find a schooner and I'm not seeing it.
All right. Thank you.
What? That could be a leaf for all I can tell. Okay.
And Sergeant, do you recognize what's depicted on the screen and has now been marked as exhibit 482?
I do.
You know, I'm going to see counsel at sidebar for just a minute, please.
Judge Canone perhaps getting impatient. Let's see. We're going to fast forward through this.
You are unmuted.
I'm sorry, Ms. Gilman, 7682. And Sergeant, do you recognize what's up on the screen as exhibit 482?
I do.
What do you recognize that to be? Is
A red piece of plastic.
that the same piece of plastic, a close-up image from the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7684. Sergeant, do you recognize what's up on the screen and has now been marked as exhibit 484?
I do.
And what do you recognize that to be?
A white clear piece of plastic and a red piece of plastic.
And lastly, from this, sir, Ms. Gilman, if I could have 7687. Sir, again, do you recognize what's up on the screen? It's now been marked as exhibit 487.
I do.
Now, Sergeant, with reference to the photos before you, have you had a chance to review that set of 10 as well?
Not this one yet. Not yet.
If you could, please.
Items that were located in the street, being the black cocktail drinking straw, and then black pieces of plastic, molding plastic, and clear pieces and molding from taillight.
May I approach, Your Honor?
Yes.
Almost to introduce and minutes next time, please.
Any objection, Mr. Jackson?
None, Your Honor.
what we need from 495.
Thank you.
Thank you. Your Honor, with the court's permission, if I could display some of these photographs to the jury.
Okay.
Ms. Gilman, if I could have 7688. And Sergeant, do you recognize what's up on the screen?
I do.
What do you recognize it to be?
It's the wide shot of the drinking straw being found on the edge of the roadway in front of 34 Ferry Road.
Oh, I
Sergeant,
see
if
it.
you could, using the laser pointer before you, if you could direct the jury's attention to where you observed that straw. And Ms. Gilman, if I could have 7689. Sergeant, what are we looking at in this photograph?
It's a close-up view of the same straw.
Ms. Gilman, if I could have 7692. And Sergeant, do you recognize what's up on the screen and has now been marked as Exhibit 492?
I do.
And what are we looking at in 492?
Piece of plastic next to a measuring ruler that's provided for comparison and by the crime scene photographer to document the item.
And Ms. Gilman, if I could have 7695. For the record, this is now Exhibit 494. Sergeant, what are we looking at in 494?
It's the same item from just prior, just zoomed in more, showing the detail of the black molding, the clear clear plastic, and red plastic.
Sergeant, as far as those photographs before you, have you had a chance to review those?
Yes, I have.
And do you recognize what those are?
Yes, I do.
And what do you recognize those?
There are pieces of red plastic, pieces of clear plastic, and a piece of glass.
May I approach, Your Honor?
Yes.
I'm about to seek to introduce and admit the next 10 exhibits.
No objection.
Thank you.
Your Honor, with the court's permission, if I could publish just a few of these photographs for the jury as well.
Okay.
And Ms. Gilman, if I could have photograph 7700. For the record, this is now Exhibit 498. Sergeant, if you could describe to the jury what we're looking at here.
We're looking at a red piece of plastic next to a measuring ruler on the edge of the grass on the property at 34 Fairview Road by the road.
And if you could, sir, using that laser pointer, just direct the jury's attention to where you observe that item to be within this photograph.
Right there.
Ms. Gilman, if I could have photograph 7705. And for the record, this is Exhibit 502. And Sergeant, if you could, again, describe to the jury what, if anything, of significance you note in there.
It's a shard of red plastic next to a measuring ruler.
Ms. Gilman, if I could have photograph 7708. For the record, this is now Exhibit 504. Again, Sergeant, if you could, using a laser pointer, direct the jury's attention to what, if anything, of significance you note in this area.
There is a black piece of plastic molding next to a measuring ruler.
And lastly, from this set, Ms. Gilman, exhibit, photo number 7712. Again, for the record, this is Exhibit 508. And again, Sergeant, if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you note in this.
A clear piece of plastic next to a measuring ruler.
That's found on the grass area as well, is that correct?
That is correct.
Now, Sergeant, with reference to that new set of photos before you, have you had a chance to review those?
Yes, I have.
And do you recognize what's contained within those photographs?
Yes, I do.
And what do you recognize that those photographs to contain?
They contain small red pieces of plastic from 34 Fairview Road on the grass area where we located the others. Also contain a flimsy piece of circular, like very malleable plastic, clear plastic. In addition to that.
May I approach, Your Honor?
Yes.
Come on, seek to introduce the next 10 exhibits.
No objection.
Thank you.
Ms. Gilman, if I could have photograph 7715. For the record, this is now exhibit 511. Sergeant, direct your attention to the screen if you could, using that laser pointer, direct the jury's attention to what, if anything, of significance you observe in this photograph.
That is the thin, malleable, circular in shape, a piece of clear plastic that was located in the lawn area of 34 Fairview Road.
Now, lastly, Sergeant, there's that set of photos that I just placed before you. Have you had a chance to review those?
Yes, I have.
And do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those to be?
There are items. Those are items recovered in the lawn at 34 Fairview Road. Those items are a shard of glass, a BPD baseball hat with an American flag, and stains of blood.
Your Honor, may I approach?
Yes.
I'm going to introduce the minutes next. 16 exhibits. Sorry. Your Honor, with the court's, I'm sorry. Your Honor, with the court's permission, may I publish some of these photos for the jury as well?
Yes.
And Ms. Gilman, if I could have photograph 7727. For the record, this is now exhibit 520. And again, Sergeant, if you could direct the jury's attention to what, if anything, of significance you observed in this photograph.
I observed a shard of glass next to a measuring ruler.
And Ms. Gilman, if I could have 7729. For the record, this is exhibit 522. And again, Sergeant, if you could describe to the jury what we're looking at.
It's a larger piece of red plastic with black molding around the edge, located next to the telephone switch box on the grass area at 34 Fairview Road.
And Ms. Gilman, if I could have photograph 7733. For the record, this is exhibit 526. And Sergeant, from this photograph, what, if anything, are we looking at here?
This photograph here depicts the area which we are excavating during the morning hours of February 3rd, 2022. As the shovel works its way towards the grass, my laser pointer is directing your attention to Mr. O'Keefe's hat that was compacted underneath the snow on the ground.
Now, as far as this photograph is concerned, does that accurately depict the depth of the snow that you were digging into and sifting through on the morning of February 3rd?
It does.
And that, again, is several days after the blizzard of January 29th, correct?
That is correct.
And Ms. Gilman, if I can have photograph 7740. For the record, this is exhibit 530. And again, Sergeant, if you could describe to the jury what we're looking at here.
We're looking at Mr. O'Keefe's hat on the grass, pressed down and compacted to a flat surface underneath the snow, which has been excavated around it.
Thank you very much. Ms. Gilman, you can take that down. Thank you, Mr. Ross.
Thanks, Joe.
Sergeant, on February 3rd, 2022, is that the first time that you had been at 34 Fairview Road?
Yes, it is.
And with respect, if I could turn your attention briefly to the following day of February 4th, did you have occasion to go back to 34 Fairview Road on that day?
Yes, I did.
And what brought you to 34 Fairview Road on February 4th?
Having excavated those items on the 3rd, I directed the troopers in my office, who obviously reside in the communities around us, to make a point to travel by that location every day on the way to work and every day on the way home. The purpose of that was to see if anything else was to reveal itself as the snow naturally melts away and items could present themselves. So on the February 4th, as I am traveling to work, I diverted my typical route of travel to go by 34 Fairview Road. Just prior to my arrival, I received a call stating that there was Canton Police representatives at the scene, and more items have been revealed due to the melting snow, and that I should come collect those items. I was down the street. I arrived and collected the item that presented itself.
Okay, here's a question. Wasn't Canton PD already conflicted out from doing any sort of evidence gathering? I mean, he even testified to that earlier on in his direct examination. So why is Canton PD searching the scene for more items? Right? Did I hear that right? Or was it just Canton PD that notified him? Like, why would Canton PD then be in the process of notifying him, even if it was Massachusetts State Police? That's weird.
And if you recall, that item that you collected on February 4th, was that located on the lawn, on the street, or something else?
It was on the lawn.
Now, with reference to your collection of these items, either on February 3rd, February 4th, or on any sort of subsequent date, how were they collected, and what exactly did you do with them in reference to the seizing of the items and storage of the items?
Each item that was collected was placed in a evidence paper bag. The collection was done by utilizing latex gloves to prevent any transfer of evidence from fingerprints to DNA onto those items. Then those items were transported to our office, logged into the system, and stored in the evidence lockers at the office.
And each of those respective bags of items or evidence, they were sealed as well, is that correct?
That's correct.
Now, turning your attention to February 10th of 2022, did you have occasion to go back to 34 Fairview Road on that day as well?
I did.
And what, if anything, did you observe, or what, if anything, did you seize on that particular day?
We seized more shards of glass and plastic.
And if you know, or if you recall, how many pieces did you seize on that particular day?
My memory's exhausted to that, but the exact numbers annotated in on the bags that the items were placed into.
Your Honor, may I approach?
Yes.
I'm showing you documents, just ask you to look at that section and look up in your. Your Honor, may I approach?
Yes.
Sergeant, is your memory refreshed as to how many items or what the items were that you recovered on February 10th?
Yes, it is.
And what were those items and how many, sir?
There was 6 items of clear red and black plastic and 14 items of plastic and glass.
Now, in addition to the dates that you were present at 34 Fairview Road and recovered items, them being February 3rd, February 4th, and February 10th, were there other dates that you're aware of that items were recovered by troopers that you supervised?
Yes.
And if you recall, what were those dates?
The dates were January 29th, February 11th, and February 18th.
Were there items recovered on February 8th as well?
Yes.
Now, as far as your direction or having, let me first start with you. So on the dates that you were there, February 3rd, 4th, and 10th, were you alone on those dates, or were there other troopers with you when you were there?
On the 4th, I was alone as far as state police personnel. There were other Canton law enforcement representatives at the scene with me as I collected that one item. On the other days, I was accompanied by other troopers.
And as far as you know, obviously not being present, but from your supervision of these troopers, were there other occasions where individuals were at 34 Fairview Road? Were they alone, or were they with a group of troopers?
Objection.
Sustained.
Yeah, that'd be
Now-
speculation.
As far as the items that were recovered,
That would be speculation because he doesn't know if he's not there. He doesn't know if the other ones are by themselves. That would be based on hearsay that he would have any sort of knowledge to answer that question.
when you were there on February 3rd, February 4th, and February 10th, did you have occasion to bring those items with you to court today?
Yes, I did.
And Your Honor, may I approach?
Yes.
I'm presenting you with a box. First, just ask if you recognize that box.
I do.
And what do you recognize that?
It's the box storing items logged into evidence as they relate to this case.
And Your Honor, with court's permission, may the sergeant open the box?
Yes.
Thank you.
What's in the box, man?
Now, first, Sergeant, with regard to the items as far as plastic and or glass that you recovered from 34 Fairview Road on February 3rd, if you could locate those items. Copy taken. And Sergeant, with respect to each of those bags, they contain items of evidentiary value, whether they be plastic or glass, that were recovered on February 3rd. Is that correct?
That's correct.
And I'm sorry, how many bags in total do you have there before you?
I have 3 bags, 2 containing broken glass and plastic, and a steering straw, broken red plastic and clear plastic, and a bag containing 1 black Boston Police Department hat.
Your Honor, the Commonwealth will seek to introduce in minutes the next 3 exhibits.
No objection.
Okay.
No particular order.
Five 536, and 537.
Thank you.
Your Honor, with respect to what's now marked as Exhibit 537, with the court's permission, may the sergeant remove that item, the hat, from the bag and display for the jury.
Yes.
That's going to be the hat.
Thank you, sir. You can place that back in the bag. Sergeant, from your observations of Mr. O'Keefe on surveillance video from both C.F. McCarthy's and the waterfall on January 29th, what, if any, similarities did you observe between the hat which you just displayed and located on the lawn of 34 Fairview Road and the hat Mr. O'Keefe was wearing in those videos?
It appears to be the same exact hat.
Now, Sergeant, with reference to the box of other items, if you could remove what, if any, items you recovered and seized from 34 Fairview Road on February 4th. And again, sir, just for the record, what's contained within that bag from February 4th?
Contained within the bag is a piece of red, hard plastic taillight cover.
Your Honor, the Commonwealth will seek to introduce in the minutes the next exhibit.
No objection.
Thank you.
Exhibit 538.
And lastly, Sergeant, with regard to the box, if you could remove the items that you seized from February 10th, 2020. And Sergeant, with respect to those 2 bags of items, if you could just inform the jury what is contained within those bags.
Bag labeled item number 10 contains 6 pieces of red, black, and clear plastic. Bag labeled number 11 is containing 14 pieces of glass and plastic fragments.
Thank you, Sergeant. Your Honor, the Commonwealth will seek to introduce and admit as the next 2 exhibits.
Any objection, Mr. Jackson?
I'm sorry. No, Your Honor. Thank you.
Exhibit 539 and 540.
I'm sorry. Was that 539 and 540?
Yes.
Thank you, sir. Moving on from that, if I could bring you back just one last time to bring videos from One Meadows Ave, as far as you had testified earlier that there was no video that you observed of the defendant, Ms. McCabe, and Ms. Roberts looking at the passenger side taillight area of the vehicle, correct?
That's correct.
Was there any video of the defendant, Ms. McCabe, and Ms. Roberts actually leaving from One Meadows Ave on that morning of January 29th?
There was not.
Now, as far as the videos that were not there, as far as the defendant, Ms. McCabe, and Ms. Roberts leaving, the next video depicted Mr. Camerano arriving at the residence to pick up Ms. Furbush, correct?
Yes, that's correct.
And with regard to the missing video of the defendant arriving at One Meadows Ave on January 29th, sometime after midnight. The video immediately preceding that, again, would have been Mr. Camerano arriving and picking up his daughter from One Meadows Avenue sometime around 11:30 p.m., correct?
That's correct.
And those videos were both present, correct?
That's correct.
If I could bring you back to February 3rd, 2022. On that date, did you have occasion to meet with a gentleman by the name of Brian Higgins?
Yes, I did.
And when you met with Mr. Higgins, who, if any, one from your office was with you when you met?
Trooper Mike Proctor was from my office present during that interview.
And during the course of that interview, what, if any, documentation did Mr. Higgins provide you with?
Mr. Higgins provided me with a printout of a Celebrate extraction containing conversations via text message between him and Mr. John O'Keefe and between him and the defendant. He also provided a digital copy of the same extraction on a CD.
Now, what, if anything, did you advise Mr. Higgins of at that time as far as Mr. O'Keefe's phone and the defendant's phone?
I advised Mr. Higgins that we were in possession of both of those devices and would have the extraction and accurate documentation of those conversations.
And did he seem to understand that when you told him?
Yes, he understood it.
Objection.
Sustain.
Yeah,
Strike.
speculation.
Strike that, folks.
Now, also on February 3rd, at some point, did you have occasion to go inside of 34 Fairview Road?
Yes, I did.
And who, if anyone, did you interview inside of 34 Fairview Road on that day?
I interviewed Mrs. Albert.
That would be, just for the record, Nicole Albert, is that correct?
That's correct.
And who, if anyone, was present with you during that interview of Nicole Albert?
It was Trooper Mike Proctor was present with me.
Anybody else from the Albert family present in the home or present during the course of that interview?
Mr. Brian Albert was also present. I don't know who else exactly was present in the home. I just know that those two residents were in the room with us.
And where was Brian Albert at the time that you conducted the interview of Nicole Albert?
In the room with us, seated next to her.
Now, with reference to, I'm going to ask you just a little bit about sort of the interview process as far as the interviews that you conducted in this case.
Yes.
If you could describe to the jury, starting with sort of how many people from your unit are present for a given interview and how those interviews are conducted.
We conduct interviews always at pairs. I think I mentioned it yesterday. Typically, during a regular investigation into a homicide or any death investigation, we pair up our troopers with a local detective. In this instance, since Canton had recused themselves from interview portion of the investigation, they were not going to provide manpower for those interviews to be conducted. Thus, we had to utilize only troopers from our office in order to conduct those interviews.
And typically, obviously not perfect, but as far as the interviews that you were present for, about how long a period of time, generally speaking, were the interviews that you conducted in this case?
From my experience, I have learned that to fully communicate a course of recollection of events that an individual observes, experiences, or is aware of, and understand every detail of that experience, it would take approximately 45 minutes at a minimum to conduct a full interview with a witness in detail.
Now, sir, if I could turn your attention to June 9th of 2022. On that date, at some point, did you have occasion to meet with the defendant?
Yes, I did.
And at some point during that meeting, did you have conversation with the defendant?
Yes, I did.
And was that conversation, or at least portions of it, memorialized in any way?
Yes, it was.
Your Honor, may I approach?
Yes.
I'm showing you a disc. Does that contain an audio recording, to the best of your knowledge? Does that contain an audio recording of a portion of your conversation with Ms. Reed on June 9th, 2022?
Yes, it does.
Your Honor, may I approach?
Yes.
I'm also seeking to introduce the minutes of the exhibit.
All right. No objection, Mr. Jackson? All right, folks, before we play this, again, please be mindful of the instruction from yesterday. So you're about to hear statements allegedly made by the defendant, allegedly concerning the crimes with which she's charged in this case. Before you can consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether the statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or any questioning by the police, the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor, and you must consider the totality of the surrounding circumstances.
Okay, so now we're going to get an audio recording of Karen Reed in her interview on June 9th, 2022. So this is all, technically this would be hearsay, but because this is the defendant in the case is being introduced by the prosecution, this is another example of a statement by an opposing party. By a party opponent, I guess is technically the phrase for it. So this all comes in properly. This is anything that she says to the police, that can all come in. So interesting that it's a portion of the interview as opposed to the entire portion. We'll see if there's anything that's been cut out, for context that comes in on cross-examination. But yeah, so we'll see. Also, I'm gathering all the questions that I'm seeing in the chat. So we'll be answering those at some point soon.
Your Honor, with the court's permission, may we publish that for the jury at this time?
Yes, you want to turn off the air conditioning? Is this very short, right?
It is very short, and if we could, please, yes.
Yeah. And this is just audio, correct?
So you're aware you speed up the brand calling number. We're all in on the same joke, right? My tail end is correct and John's is pulverized.
Okay. Now, Sergeant,
I wish they would
on hearing that
replay
statement
that.
from the defendant, what was your reaction?
Objection.
Sustained.
On hearing that statement, what, if anything, did you do?
I advised the defendant not to further speak.
Objection.
I'll allow that.
Now, at some point over the course of your investigation, were you made aware of forensic findings relating to the defendant's tail,
Yes, I was.
and specifically DNA findings,
Yes.
and specifically that there were
Objection.
Sustained. Yes. You can turn the air conditioning.
Okay. We're going to fast forward through this part, through the sidebar.
You're on back? Have one moment.
Yes.
So, Sergeant Bukhenik, on January 16th, 2024, at some point in that day, did you meet with a Sergeant Gallerani of the Canton Police Department?
I did.
And who, if anyone else, well, let me ask you this. As far as any other troopers from your office, who, if anyone else, was there with yourself and Sergeant Gallerani?
Trooper Mike Proctor.
And what was the purpose of your meeting with Sergeant Gallerani, Trooper Proctor, on that morning?
Collection of our DNA.
And was that something that you did voluntarily?
Yes.
And how was it that the sergeant collected your DNA?
Through a buccal swab.
And were you present when Trooper Proctor submitted to a buccal swab as well?
Yes, I was.
And then as far as the swabbings that were taken from both yourself and Trooper Proctor, were those logged into evidence by you, or did Sergeant Gallerani take them with him when he left?
Sergeant Gallerani took him when he left.
Your Honor, may I approach?
Yes.
My apologies, Your Honor.
That's okay.
Thank you very much, Sergeant. Your Honor, I have no further questions.
Okay.
Oh,
Cross-examination?
Thank you, Your Honor.
cross.
Sergeant Bukhenik, I want to start with one of the latter things that you discussed with Mr. Lally, and that's specific to the ring video that y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video or series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper Mike Proctor received it.
And who ultimately either logged those into evidence or controlled those once they were received from the Ring Corporation?
I believe it was Trooper Mike Proctor.
And ultimately, Sergeant Bukhenik, you did note that in addition to just the physical videos themselves, that login information and login keystrokes, et cetera, were requested from the Ring Corporation as well, correct?
There was discussion with Ring asking for those logs.
I'll call it, is it correct to say an activity log?
That's what was requested, yes, activity log, yes.
So ultimately, the activity log would show who logs in, who accesses the data, things of that nature, correct? Or at least that was the hope.
That is what was requested.
All right. It would also show logging in and executing deletions, manipulating the log files, things of that nature, correct?
That is what was requested, yes.
When you reviewed those log or activity logs, there was no evidence revealed that my client ever logged into that account, correct?
There was no activity logs provided by Ring.
So you have zero, hang on. Isn't it true that Ring contacted Trooper Proctor and indicated that they had created a Dropbox folder that contained the evidence that had been sought in the search warrant?
Objection.
Sustained.
Isn't it true that the search warrant return specified account information, video recordings, and number 3, activity logs associated with video recordings are all times displayed in UTC?
I'm not aware of that, no.
Do you recall that activity logs were in fact provided from the Ring Corporation?
I do not recall that, no.
Okay. May I approach briefly?
Yeah. So this is a very interesting start here. Jackson, right out of the gate, is like, okay, who signed the search warrant? Who, received the videos from Ring Corporation? Who maintained custody of this footage when it actually came back from the Ring Corporation? Proctor. All of this is to point out to the jury, you've got to be hearing from Proctor. This is someone who you need to hear from. If you don't hear from him, there's something weird happening here. He's the guy that has his hands all over everything. This is all kind of signaling to the jury his importance in this case. So once again, just like we were saying at the very beginning of the stream, going into the testimony for today, if the prosecution doesn't call him, I think there's a big problem. I think there is a big problem. And the defense is going to jump all over his testimony if in fact they do. I mean, either way, they'll jump all over his testimony. But if they are the ones to call him, it's going to be that much worse for the prosecution, in my opinion. And now, he's, Bukhenik is trying to answer this stuff about what was returned, the activity logs, which are very important here because there is this allegation, I suppose, that the Ring footage was manipulated by Karen Reed, that she somehow accessed this information and deleted some footage or manipulated some footage. The activity logs would show that. And so if Bukhenik says, well, there weren't any activity logs from Ring Corporation, but if that is accompanied by an explanation that all of the activity logs that they had that would be showing anyone accessing during those time periods, the footage or deleting the footage or manipulating the footage, then that would be in the activity logs. They would have activity logs to present. So if that explanation, is something that would have been provided along with their response to the subpoena for all of that data collection, so then that's something that could and should be testified to. But if Bukhenik doesn't have the knowledge to be able to testify to that, he doesn't have the knowledge, right? That would be speculation. But that's why it's just pointing out again that this is someone that we need to hear from is Trooper Proctor to get these answers.
Take a look, Sergeant, at that paragraph with my fingers on it, like the third paragraph down, the middle of the page, and review that to yourself and let me know when you're finished.
All right, let's continue through here.
May I approach, Your Honor?
Yeah.
Okay.
Have you had an opportunity to review that?
Yes.
May I approach, Your Honor?
Yes.
Thank you. Does this refresh your recollection as to the items received from the Ring Corporation?
That is the first time I saw that document, so it does not refresh my recollection. I simply read it.
So do you have a recollection as you sit here that in fact during the course of your investigation, the three items that you received from the Ring Corporation were the account information, the video recordings, and quote, activity logs associated with the video recordings, all times displayed in UTC?
To the extent of its availability, as it says in that document.
Okay. The long and short of it is, during the entire course of your investigation, you never revealed that investigation never revealed any evidence whatsoever that my client ever even accessed the account information for the Ring account associated with this search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
Thank you. Trooper Proctor, you were notified.
I am not Trooper Proctor.
I'm sorry. No, you're not.
I'm sorry. That was such a Freudian slip by Jackson. And I don't think that was intentional. I think that he really was intending to address him as officer, as Trooper Bukhenik. But it's just funny that he's like reminding the jury, even just like subconsciously, yet again, that this is not Trooper Proctor, that's who they want to be, that's who they should be hearing from. Who knows if they want to be, that's, speculative, but, that they should be wanting to hear from him. That's funny.
Sergeant Bukhenik.
Sergeant Bukhenik.
How do I say it?
Bukhenik.
I'll give that a shot.
It's fine.
Bukhenik?
Yes.
Is that better?
That's better. Thank you.
If I screw it up again, please. On January 29th, you were notified about a Boston police officer found gravely injured outside the home of 34 Fairview at about 6:40 in the morning. Is that your testimony?
That is not.
What time were you notified?
I was not notified it was a Boston police officer.
So you didn't have that information upon the first notification?
I did not.
Okay, what information did you have?
There was a male party in the snowbank, possibly of a heart attack.
At what point did you learn that the individual was, in fact, a sworn Boston police officer?
I do not know exactly when I learned that he was a Boston police officer.
You think it was during that day or the following day?
It was most likely that day, either. Yeah.
Fair enough. Trooper Proctor was ultimately assigned as the, what did you call him? Not lead investigator, but case officer?
That's correct.
He was assigned on the 29th, correct?
He was on call from 7 a.m. on January 28th until 7 a.m. on January 29th.
So his assignment was, he was assigned on the 29th because he was on call.
He was on call. His assignment took effect when the schedule came out back in mid-December.
Okay. Well, he wouldn't be assigned to this investigation until there was a need for the investigation, right? And that's all I'm getting to. I mean, once the call came in, he was the assigned case agent.
Once the calls come in, the person that's on call is automatically assigned that case.
All right. did you personally, as his supervisor, did you personally respond to 34 Fairview at any point on January 29th?
No, I did not.
Did Trooper Proctor, at your direction or on his own, ever respond to 34 Fairview Road at any time on January 29th?
No, he did not.
Based on your initial investigation, and I'm talking about going way back, Sergeant, on your initial investigation, by 10 or 10:30 in the morning, 10:40 in the morning, it was your belief that Mr. O'Keefe had been struck in the face by a person. That was your initial understanding of the circumstances surrounding the investigation, correct?
My initial understanding was that the defendant stated that she hit him. We did not know the...
Sergeant, you hadn't even met my client at that point. You hadn't interviewed a single witness by 10:41 in the morning, correct? Not one witness.
That's not correct. We had already interviewed the first responders.
Okay, when I say witness, I'm talking about civilian witnesses. So at 10:41, you hadn't interviewed a person at 34 Fairview or associated civilians associated with this incident, correct?
At that point, no civilians have been interviewed, no.
But at 10:41, Sergeant, you contacted Good Samaritan Hospital to inform them that, quote, Mr. O'Keefe was struck in the face with a cocktail glass, end quote, correct?
I do not recall contacting Good Samaritan Hospital.
May I approach?
Yes.
Interesting. Is he going to impeach? Sounds like it.
I'd like you to take a look at this document, and if you wouldn't mind, pay special attention to the second page, the bottom paragraph where it's tabbed in pink.
Yeah, is this another case of cross-examination? He was very, very detailed yesterday. Okay. Reading through this statement. I'm going to fast forward.
May I approach?
Yes.
Oh, we're almost caught up.
Thank you, sir. Having reviewed this, does this refresh your recollection that you contacted Good Samaritan Hospital and gave them an assessment, at least based on your investigation at that time?
That is not true.
What did you say to Good Samaritan Hospital?
I never spoke to Good Samaritan Hospital. That document is for the medical examiner's office.
So anytime there's been a document that's been prepared by someone else as a report of what the conversation was, whoever it was that didn't write the report is like, that didn't happen. It wasn't me. I mean, come on. Like this has just happened too many times in this trial so far. Like how many police reports where Jen McCabe or Matt McCabe or someone else supposedly said something, either the report left something material out or the report added something material in, and they're just like, nope, they got it wrong. They got it wrong. I definitely did say that, or no, I didn't say that. And now this is another example. The medical examiner is now the one that's lying.
I'm not asking you where the document is from. I'm asking you if the document says Trooper Yuriy Bukhenik called back at 10:41 stating the case is now being treated as a suspicion.
The objection sustained.
Did you call back to Good Samaritan Hospital and say that the investigation was being treated as a suspicious due to a domestic situation? Did you say that?
I never spoke to Good Samaritan Hospital.
did you say that there's a possibility that D was struck in the face with a cocktail glass?
Objection.
Sustained.
Did you ever contact anybody at any medical facility and indicate that the investigation was being treated as a suspicious, in quotation marks, because the victim appeared to have been struck in the face by a cocktail glass? Did you ever say
Objection.
that?
Allow that. Did you ever say that?
Yes, Your Honor. Yes, I did say that to the medical examiner's operations desk.
Okay, so when I was asking you if you ever said it to Good Sam, and you said, no, that's not true, that's never happened, you were correcting me on the fact that it happened at the medical examiner's office, not at Good Sam.
I responded and answered your question honestly, yes.
Oh my
Okay,
God.
So honestly,
Oh, come on. Ugh. Okay, sure. I mean, yeah, this guy he's very specific. We will give him that. However, you know, it also is very helpful if he said, I mean, what we care about is the fact that he said it to somebody. He said it to somebody that was put down into a report, right? And so, you know, he got, you know, bogged down on the fact that Jackson was saying, well, you said it to Good Samaritan Hospital. You know, and that is entirely fair. Technically, this testimony is accurate, right? He didn't lie when he said that he never called Good Samaritan Hospital. Jackson got that wrong, but you know, this witness is obviously not being particularly helpful on cross, and that's also fair because this is, you know, this is a cross examination. But it's just. Then he gets to that point where he's like, no, I just answered your question. I don't know. The jury might still look at that and be like, guy, come on.
you did, in fact, at 10:41 a.m., indicate to another professional involved in the investigation that the circumstance was being treated as a physical assault at that point, correct?
I communicated our suspicions to the medical examiner's office.
And that was at 10:41 or thereabouts in the morning, correct?
That's correct.
Your initial investigation during those obviously critical hours, the beginning hours, led you to believe that there was at least a good possibility, you indicated that you made a phone call, that it was a physical altercation that led to John O'Keefe's death, correct?
That's correct, yes.
What steps did you take, sir, in those moments, to determine whether someone in the house at 34 Fairview may have been involved in that physical altercation that you suspected at the time?
As investigations develop, we followed the evidence and statements made. The steps I took was Trooper Proctor and I proceeded to an eyewitness who was also present at the scene when the victim was discovered and interviewed Ms. McCabe.
And prior to interviewing Ms. McCabe, by the way, that was at Ms. McCabe's home, correct?
That's correct, yes.
Even though you believe that there may have been a physical altercation, you didn't ask anybody to come down to the station. Is that right? Any of the witnesses?
That's correct.
And you did not seek to actually go to the physical location of 34 Fairview in those next few hours?
That's correct.
Or the next few days, correct?
Not myself, no.
Okay. As a matter of fact, Trooper Proctor did not either, did he?
No, he did not.
You didn't secure the interior of the house as a potential crime scene. You certainly know how to do that, right?
That's a compound question. Do you want me to answer whether I did it or whether I know how to do it?
Well, I'll ask the question. If you can answer it, please answer it.
Okay.
Can you answer that question?
I can answer that question.
Why don't you answer both of them then?
First portion is we did not secure the home as a crime scene. And the second portion, yes, I do know how to do that.
And you didn't, as a Massachusetts State Police official, you didn't secure the outside as a crime scene either, did you?
I did not know.
To your knowledge, nobody else from Massachusetts State Police ever did either, did they?
Yes, they did.
How was that done and when?
when members of our office and the CERT team responded to that location and secured the front yard grass area and processed it.
That was at 5:45, 6 o'clock that night on the 29th?
I believe it was earlier, but I was not present, so I can't testify to the time.
So you don't know personally what they did to quote unquote secure or not secure the crime scene. You know they searched it, but in terms of securing it as a crime scene, you don't have personal knowledge to that.
I was not present.
Okay. You never took any photos of the interior of the house, correct?
I did not know.
You never caused CSSS to go inside the house and process that house as a potential crime scene, correct?
I did not, no.
No forensic criminalist at your direction ever went into 34 Fairview?
No, they did not.
And the people that you interviewed on January 29th, you already mentioned Ms. McCabe. The other people were her husband, Matt McCabe, correct?
That's correct.
And her brother-in-law, Brian Albert. Is that right?
That is correct.
And all three of them were interviewed where?
They were interviewed at
Jen
the
McCabe's
McCabe residence.
Now, yesterday when you testified, did you indicate that Brian Albert was not present in the home when you interviewed Matt McCabe and Jennifer McCabe?
They were not, he was not present in the dining room when we were interviewing each individual separately.
So if all three of them testified that he arrived before you arrived, they would all be wrong.
I did not see him in the home when we arrived, no.
I want to switch gears real quick to a couple of the physical items that you testified about yesterday, specifically the gray shirt or the gray hoodie and the orange shirt. You and Trooper Proctor collected both of those items you indicated from the floor of the hospital at Good Samaritan, correct?
That's correct.
You testified that you and Trooper Proctor immediately bagged both of those items. They were sort of sopping wet, I think you said.
That's correct.
You indicated that the bags were so wet that you had to take the items back out of the bags and then lay them out on, I think you said, butcher paper. Is that right?
The items were soaked and wet. They were bagged, double bagged, to prevent leakage of physiological fluids and the moisture coming off of it. And then once they were transported to the office, they were laid out on butcher paper in order to dry naturally.
So you went from Good Samaritan directly to Dighton, correct?
That is correct.
And then you went from Dighton directly to the Canton Police Department, after which you had seized the vehicle, correct? And the phone.
We seized the phone in the vehicle in Dighton and then followed the tow truck straight to the Canton Police Department.
So at some point, if you had received or gathered the wet clothing at Good Sam, went from Good Sam to Dighton Canton PD, at what point that evening did you finally get those items of clothing out and laid out to dry?
It was late that night, around 10 or so.
So where were the items in the meantime?
They were stored in the back passenger compartment of my pickup truck.
In those double bags?
Correct.
Who took control of the items to then lay them out late that night at the office?
I do not recall.
Is that you or Trooper Proctor?
I don't recall. I don't remember.
At some point, obviously, it was getting late. You'd been on duty for a long time that day. You went home at some point, correct?
At some point, yes.
Did you wait for those clothes to dry before you went home, or did you leave that in Trooper Proctor's hands?
No, once they were laid out in the processing area in the office, we went home.
Okay. Who would have controlled those items of evidence when you left?
Well, they're under lock and key within the secure area of the district attorney's office, so they're secured. Nobody's in physical control watching guard over them.
Who had access to that area?
Troopers in our office.
Meaning you obviously.
Yes.
Supervisor. Trooper Proctor as well, correct?
Yes. Yes.
Ultimately, given the fact that he was the case officer, sort of in charge, the lead, he would have bagged those items up, been responsible for taking those items, tagging them, getting them stored wherever they needed to be stored and processed, correct?
As a case officer, he could direct other people to perform those tasks for him. The evidence officers in the office log in the evidence, and once it was dried, it was sealed up, bagged, and put into storage. As far as who actually performed those tasks, I do not know.
Well, yesterday, Your Honor, may I approach the courts, right? There's a couple of evidence.
Oh, sure, go ahead.
Thank you. This is not a vision contest. I'll bring these up to you in just a second, but just for familiarity's sake, do you recognize these two bags as bags that you brought to court with you yesterday?
They look familiar, yes.
Okay. This one has a 437 on it on my right. The one on my left has a 438 on it. May I approach it quickly?
Yes.
I'm not going to ask you to open those. Don't worry about gloving up at this point. The bag on your left, which one is that? 437 or 438?
The bag on my left is 437.
437. Okay. And you indicated that those items were bagged after the clothing was dried and then ultimately processed in, logged in, correct?
Once the items dried, they were bagged and logged in, waiting processing, yes.
But you didn't personally do that.
No, I did not, no.
Matter of fact, looking at the bag on your right, what's been marked as Exhibit 430, help me, 438, thank you. That one has some writing on it, correct?
Yes, it has a lot of handwriting on it, yes.
And whose handwriting is that?
I don't know.
You've seen Trooper Proctor's handwriting 1,000 times, I guess, correct?
Not 1,000 times, but
Does it look like his writing?
it says Trooper Proctor on it, but other than that, I do not know what Trooper Proctor's handwriting looks like.
All right. It indicates that Trooper Proctor is the one that bagged that item or those items up, correct?
Yes, this bag indicates that the item was collected by Trooper Proctor on 129
Right.
at 10.
And it says Brockton, correct?
Good Samaritan Hospital in Brockton, yes.
You just took the question out of my mouth. That's where Good Samaritan Hospital is, correct?
That's correct.
And there's a tag or a printed label, looks like a label maker of some sort, that is on that physical bag, correct?
Yes.
Before we get to that, what's the description on that bag in handwriting?
I'm sorry, can you be specific as to description of what, or?
Where it says description of items.
Description of enclosed evidence?
Correct.
It says 1 orange t-shirt, 1 gray long sleeve shirt.
Okay. So may I approach, Your Honor?
Yes.
And before I do that, just so I close this loop, what's the description on the bag to your left, the one that looks like it's less sprinkled?
Number 437?
Yes, if you would read the same clothing description.
The description of enclosed evidence states sweatshirt with recovered items inside container.
Okay. May I approach now?
Yes.
Thank you. Yesterday when you opened, I'll keep my voice up. Yesterday when you opened these two bags, this one, 437, has the gray sweatshirt in it. 438 has the orange t-shirt in it now, correct?
That's what was in the bag, yes.
All right. However, the bag indicates at one point, this bag, 438, the physical bag I'm holding in my left hand, had both the sweatshirt and the t-shirt together, correct?
That's what the description is. I do not know if that was in case or in fact the case.
The reason you don't know is because you're not the one that bagged them. Trooper Proctor did, correct?
The reason I don't know is I wasn't present during the separation of those items, and I did not observe it taking place, nor was I made aware of how the items were separated or when.
You are aware, however, that
That's another, indication by the defense. Trooper Proctor's the one who did it, right? Which the witness didn't exactly respond totally affirmatively, but that's they keep digging that one. They keep poking that topic of Trooper Proctor needs to testify. Trooper Proctor has information. Trooper Proctor is someone the jury needs to hear from.
tag that's on the label maker looking tag, the white tag that's on that bag indicates that indicates a date of February 4th, correct?
You'd have to bring that back up.
I'm sorry.
I didn't take note of that.
My fault. May I, Your Honor?
Yes.
Let's direct your attention to the tag and the date associated with that tag.
The label maker tag does have the date February 4th, 2022 on bag number exhibit 438.
May I approach?
Yes.
Thank you, Sergeant.
Yep.
That's obviously 6 days after the item was actually recovered on the 29th, correct?
Yes, it is.
So that indicates, at least based on that tag, that that item was not booked into evidence and processed until 6 days after it was actually recovered on the floor at Good Samaritan Hospital. Is that right?
The date indicates February 4th, 2022.
Right, and that date would be indicative, in your experience, of the date that it's moved into processing by some other folks, the evidence sergeants or whomever, or the evidence officers rather, or whomever, correct?
I can't speak to their procedures as far as when they print the date. That date could be when they printed the label, but the bag might have been tagged otherwise. I do not know that.
But there's no other tag on that bag that suggests an earlier date, correct?
There's just that one tag from the label maker.
My question to you, if you know, sir, and you may not know, is what was happening to these items between January 29th, after you lost sight of them that night on the butcher paper, and February 4th, when that tag indicates that they were first processed?
To the best of my knowledge, those items were drying on the butcher paper.
For 6 days?
If that's what the label maker says, yes, for 6 days. They were soaking wet.
And those would have been certainly accessible to and in the possession of the lead case officer in the case, is Trooper Proctor, right?
Yes, if Trooper Proctor needed to review those items, he would have access to those items. Absolutely.
And you're also aware that the first actual log of any chain of custody for those items is March 14th, when they were finally submitted 6 weeks later to the crime lab.
That is not true. The first actual log of those items is when we collected them from the hospital.
Where's the log? I'm talking about a physical log, like sign in, sign out log. Where's the log?
It's documented in the reports saying that we collected them.
I know that there's a report. Anybody can write a report, right? I can write a report. Doesn't mean anything. I'm asking for a log.
Objection.
So the objection sustained.
Argumentative. That's why.
Obviously, when items move in and out of people's custody in an official capacity for the Massachusetts State Police, there's a log of that, correct?
It's documented. Yes,
Or at least it should be, correct?
it's documented.
Where's the log of these items before March 14th?
It's documented in the report.
There is no log, is there, Sergeant?
I do not know.
Okay. I want to talk a little bit about some searches that Mr. Lally asked you about, February 4th and February 10th, very specifically. Both of those searches you were involved with out at 34 Fairview, correct?
Correct.
But Sergeant, you didn't personally write a report about your conduct at 34 Fairview on either of those 2 days. In other words, you didn't go back to the station and generate a report yourself.
I don't recall doing that, no.
There were no photos that you took of the items at the location.
I did.
Somebody else took photos, correct?
I did not take photos of the items. No.
Okay. And the first report that indicates anything that happened or was recovered at the location on either February 4th or February 10th, that was first notated in a report dated November 4th, 2023, year and several months later, correct?
If you say so, I do not know the exact date. That report would have to be presented to me.
May I approach?
Yes.
You don't have to read the whole thing, but if you can
That's more than a year and a half
skip
later.
to the part that talks about the February 4th and February 10th searches.
That's the first time someone wrote a report about it.
I'm sorry, I didn't realize you were finished already. What's the date of that? Well, let me ask a foundational question. Does that refresh your recollection as to the date of the report that actually talks about the February 4th and February 10th searches?
It does.
And what's the date of that report, sir?
This report is dated November 4th, 2023.
Thank you. May I approach?
Yes.
Thank you.
Jeez.
Now,
Come on, man. Really? The first time that there was a report written about those 2 searches on the 4th and the 10th, it was November 4th, 2023. Was this after the Google search came out and after other stuff came out that revealed this conspiracy theory by the defense? Like, is this another thing that kind of sort of changed later on when it was convenient for the prosecution? Like, if that's the case, I don't know, man.
Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
Yikes. Yeah. Going from February 2022 to then November 2023. That's wild.
as it relates to those 2 searches, I'd like to ask you a little bit about the February 4th search first. You indicated that you actually responded to 34 Fairview personally, correct?
I was responding to that location on my own. I personally responded, yes.
Okay. That was because you had received information that Chief Berkowitz had seen something or found something. Is that right? Chief Berkowitz from Canton PD.
That is not correct, no.
Okay. So when you got there, was Chief Berkowitz there?
Yes, he was.
You just happened to go by 34 Fairview at the exact same time on the exact same date as Chief Berkowitz, or was that coordinated in some way?
There was no coordination between me and Chief Berkowitz. As I testified, I had directed the troopers to go by the location. I planned to go by the location in the morning on the way to the office and in the afternoon on the way home, just to see if any more items would reveal themselves. So that morning, I was actually traveling to that location in order to conduct a view of the area to see if any more evidence had been revealed. Prior to my arrival, approximately while I was on Chapman Street, I received a call indicating that Chief Berkowitz was at the location, yes.
And was there also an Officer Lank, Sergeant Lank?
I do not know if Sergeant Lank was there, no.
Okay. Chief Berkowitz certainly was there.
Yes,
And Chief Berkowitz indicated that as he was driving by, he saw a piece of plastic
yes.
and stopped his car and then started making phone calls.
I believe that's what he indicated to the caller, yes.
Did you question Chief Berkowitz about why he was driving by the location in the first place?
Absolutely not.
Okay, you knew at that point that the Canton Police Department had been recused because of at least an appearance or potential for a conflict of interest, correct?
I knew they recused themselves due to only in respect to interviews. They didn't want to conduct interviews with us side by side.
Okay. So that's clarification. I thought it was also for evidence gathering, but he's saying it was just for interviews.
If there's a conflict of interest, Sergeant, for a department, conducting the interviews is just one aspect of an investigation, correct?
I'm not going to speak to conflict of interest, but yes, conducting an interview is just one aspect of the investigation, yes.
So is it your testimony that your understanding was they couldn't conduct interviews, but they could collect evidence, store evidence, write search warrants, get returns on search warrants, execute search warrants, conduct searches? They could do all that but not conduct interviews?
My understanding was they were recusing themselves from conducting interviews. They still allowed us to use their facilities. We utilized their conference room to conduct interviews. There was evidence being stored at their Sally port, being the vehicle. So that was my understanding.
Yeah, from a legal perspective, you know, when an attorney has a conflict of interest, it's like you basically can't do anything on a case. You're entirely hands off on a case. So this is strange that Canton PD would conclude, well, we're conflicted out because we don't want to have an appearance of a conflict of interest. And then to be like, well, but that only applies to interviews. That sounds strange for them to then be like, well, we have this conflict. Well, we may have this conflict of interest and we'll still gather evidence. We'll still hold on to the evidence. We'll still maintain control over all of these other aspects of the investigation. Like that is strange coming from the perspective of someone who has learned that under rules of professional responsibility for at least for lawyers, you know, which granted it's, you know, different profession, different requirements to become an attorney and all that kind of stuff. But the concept is still kind of the same, that you have a potential conflict of your own personal interest that could impact the way you go about working on that particular case where someone else's interests are impacted. It's very strange that they would then limit that only to interviews.
Isn't it true that you knew that the entirety of the Canton Police Department had recused itself because of a familiarity between one of their members, Kevin Albert, and the Albert family on whose lawn John O'Keefe was found? That was the conflict, correct?
I knew that was the connection between them, yes.
And you understood, sir, that that agency was to have nothing from an investigative standpoint, nothing to do with this investigation, correct?
They were not conducting the investigation, no.
Matter of fact, Trooper Proctor and you supervising him, y'all were conducting the investigation, right?
Our office was conducting the investigation.
So did you find it unusual or suspicious in any way that the chief of police for the conflicted Canton PD was the person driving by 34 Fairview looking for evidence?
Objection.
Can you answer that question, Sergeant?
He would have to repeat it. There's just so much I can't.
It was a little wordy. I'll try it again. Did you find that suspicious?
Which part? You have to repeat the whole thing.
That Chief Berkowitz from the conflicted Canton PD was at 34 Fairview looking for evidence.
The way you posed the question, I did not find it suspicious at all. He's the chief of the police in the town where he works, and he's driving down the street. I mean, that's not suspicious.
With a conflict of interest on the very case that he's driving by.
Objection.
Sustained.
You certainly knew as a supervisor over the case.
So that kind of a question by the defense is like, there's really no good answer, right? Because when you look at it from the way that the defense has posed that question, yeah, of course it sounds suspicious. If you're an objective person who's just looking in on this case, that sounds suspicious. That sounds weird. That sounds strange. But like, you know, if he agrees, yeah, that sounds strange, then the next question is, well, then why the hell did you allow that to happen? Or why didn't you say something? Or why didn't you look into why that was happening? You know, that there's really no good answer, because otherwise he has to answer the way that he did. which is, well, no, I didn't really see that to be suspicious. It just makes him look blind. So that's a great cross-examination question, which is where there's really no good answer by the defendant, by the witness. So just good on Jackson for asking, one of those kind of impossible questions.
Officer, that any involvement by Canton Police Department, given the fact that there's a potential conflict, any involvement by them could compromise your otherwise clean investigation. You knew that, right?
Not necessarily, no.
Did Chief Berkowitz disclose to you that morning on February 4th that he had been communicating with Brian Higgins and Brian Albert, two witnesses on your case that morning?
Objection.
Sustained.
If you knew information about communication between and among Canton PD and your witnesses, you would find that inappropriate, would you not?
Objection.
Sustained.
You returned to the scene on February 10th, is that right? To conduct another search, you said.
I was present on the 10th, yes.
Who dispatched you back to, or did anybody dispatch you back to that location on February 10th? How did you end up there is a better way to ask it.
February 10th, just like previous days, we made plans to go to the location in the morning, in the afternoon, drive by. I was on my way to work and to home. So I traveled that route on purpose. And as evidence revealed itself due to the natural melting of the snow, we would stop and collect the visible evidence.
You believe at this point, sir, that whatever you might collect at the scene would obviously be important, correct?
Anything we collected that had evidentiary value or presented itself as somehow related to the crime or the incident would be collected.
And it would be important to the investigation, right? You treat it as important.
It is important, yes.
So my question is, was, especially as it relates to the February 10th search, where there were multiple items found, did you seek to have CSSS come out and actually either mark with GPS coordinates or measure with cross coordinates exactly where each item of evidence was found?
We did not do that. We had collected so much evidence already, and so much has been documented at that point, that we did not contact crime scene services to come back out and photograph more shards of glass and plastic. We simply collected it for processing.
So the location of each one of those items was not of that great importance to you, at least at that time?
It was of great importance as to the fact that it was located in the vicinity where the victim was found and in the vicinity of other items located of the same characteristic, shape, size, and color.
So that's my question. What does vicinity mean?
In the area.
Okay, what does area mean?
It's a location, specific location.
Okay, are we talking about, because we can do this all day, I guess, are we talking about an area of 5 feet or an area of 50 feet?
Based on where the items were recovered, we're talking about an area approximately of 30 square feet between the roadway into the grass. It's the
Again, oh, okay.
We saw a photograph.
Okay. Again, I don't understand why they didn't just have Trooper O'Hara come back like the day, like on January 30th and continue the search, along with that team of guys to go shoulder to shoulder or what have you to look for evidence. Why are they doing in this sort of like lazy, we're going to drive by and see if something reveals itself? Just search the area while there's a greater likelihood of it being, I don't know, a cleaner crime scene. I don't understand why they had this sort of this other approach of like, well, we'll come back in a week, we'll come back in a few days, we'll come back, then long after snow has been melting. I don't know. I mean, to me, it doesn't make sense. These responses they're not convincing me that what they did was the proper way of doing things to get the evidence that they needed in a way that was methodical, in a way that people can objectively trust. I'm not getting convinced by this. People might disagree on that one, however. Also, Mr. W, thanks so much for the super chat. He seems to be trying to dismiss every question as silly and even smirking and smiling. Also, how is Proctor avoiding being called up to this point? Prosecution doesn't seem to want to call him yet. Maybe they will at some point before they rest their case in chief. Who knows? Who knows? I don't know. But yeah, I don't know. And the thing is, his demeanor on the stand, Officer Bukhenik's demeanor on the stand, could be interpreted as either confident or smug. It could be depending on your perspective. People who are pro prosecution might look at him and say he's confident. He knows what he's testifying about, and he knows that Jackson is full of BS, right? Maybe that's what they see. People who are pro defense, however, do not like him. I can see that in the chat right now. And so, what does the jury see? We won't know until we know. But that's great insight also.
Yes, Sergeant, of items that were butted up against a fire hydrant in one instance, correct? Is that yes?
That's correct, yes.
A drinking straw that's out in the road, correct?
That's correct.
Another shard of glass that's in the grass closer to
correct.
the flagpole, correct?
Correct.
A hat that's under the snow adjacent to the left side of the flagpole, correct? I'm sorry, it wasn't. It was closer to the electrical box, wasn't it?
No, the pictures documented where the hat was. It was to the right of the flagpole.
So these shards of glass, the point I'm asking is, did you seek to use basic cross coordinates, measurements from something that you know is a known object, like for instance, I don't know, a flagpole or a fire hydrant? 27 inches to the north and a foot and a half to the south of those two known points, that would give you a cross coordinate, correct?
It would document the exact location, correct?
And you did not do that with any of these items, correct?
The items that were not photographed were not also GPS located, but they were within the same vicinity of where the other items were collected.
But again, now we're back to the same question. Your word for vicinity might be different than my word for vicinity, right?
Objection.
Sustain.
Argumentative, that's why.
When you recover these items, or any other items, it's obviously important to memorialize on the evidence bag or in some other way exactly where they're found, who found them, the date, time, etc. Correct?
We do the best we can to document all known information on each evidence item bagged at the time.
And in terms of the February 10th search, I want to just ask you a couple of quick questions about that evidence bag. Did you bag the items into a single evidence bag that you found that day, or do you recall?
I would have to see the bag. If you have those available, I'll take a look. I can answer.
With the court's permission, exhibit, I think it's 310 that was entered into evidence yesterday. I'd like to display that for us.
Okay.
You're looking at a photograph of what was previously entered into evidence as 310. Can you see that from where you're at? I don't have the evidence bag with me, so if you don't, I can certainly ask the space to enlarge it.
If you can enlarge it, please.
Just the portion of the right.
Zoom in, enhance.
Your Honor, may I approach?
Yes.
I didn't realize I've got a photograph of it.
Do you need the lights on, Sergeant?
Please.
There you go.
Thank you.
Should make it easier. Sergeant, have you been able to familiarize yourself with that evidence bag?
With the photograph, yes.
Okay, thank you. Taking a look at that evidence bag, it has the information on it, has your name is collected by, correct?
Correct.
The date of collection is February 10th, is that right?
That's what it says, yes.
Okay. And it indicates multiple pieces of red, black, and clear plastic, right? It actually says 6 pieces of red, black, and clear plastic, correct?
That's correct.
But that is not an evidence bag that was filled out by you.
I did not fill that bag out, no.
Matter of
You
fact,
did.
That's
Trooper
Trooper
Proctor.
Proctor's handwriting.
I do not know what Trooper Proctor's handwriting is. I cannot confirm that that's his handwriting.
But it's not your handwriting.
It is not my handwriting, no.
Another.
So
There it is again. Yet another suggestion. We should be hearing from Trooper Proctor. It's like the defense is like baiting. They're baiting the prosecution with all of these suggestions, which is totally fair game, right? Because I mean, it's legitimate to be pointing out the chain of custody of this evidence. Who is the best person to testify on this? The person who gathered it, the person who signed for it, all that kind of stuff. So it's like they're Jackson's like poking at Lally, like, hey, call him. We want to hear from him. We want to bring him up. So it's interesting. Who knows if they actually will end up calling him? Also, actually, let me get these super chats really quickly here. TJM, thanks so much for the super chat. It's untenable to not call Proctor. If anyone is pro-prosecution, they'd have to be biased or should never procreate. Well, I don't want to go that far. After all, folks can have a difference of opinion in the chat. And in comments and everywhere, there are some folks that still will look back at this and say, she probably did hit him, but who knows? I don't want to go that far to be rude. After all, that is one of the rules in the chat is don't be a dingus. TJM, thanks also for this super chat. This guy looks like a Dick Tracy villain. He kind of does a little bit. Maybe it's the haircut, and the suit. TJM, also thank you for this super chat. This trial will be Exhibit A when people laugh when cops say they are honest and highly trained to be dim-witted, clumsy fools. I mean, there has been a lot in this trial of police mistakes, incompetence. I mean, red Solo cups, right? That's all we need to say to remind people of that. Dionysia Jaclo, for member for 4 months. Thanks so much for being a member for so long. Trooper Proctor is living rent free in Jackson's mind. I'm behind. It does feel that way, doesn't it? But I mean, that is because Jackson wants Trooper Proctor to be living in the jury's mind rent free. That's where he wants it. So that's why he keeps bringing his name up. He is the current boogeyman of this trial, right? Sometimes that happens where you've got a name that just keeps coming up. There's a mystery figure that is referenced, but maybe we'll hear from them, maybe we won't. And so the side that is kind of poking for that person to be brought up is invoking this boogeyman. Right now, Trooper Proctor is definitely a boogeyman for the defense. The question is he going to end up actually like a real Dementor, or is it going to be more like a poltergeist? I don't know. Am I getting those references right? In other words, is there going to be some substance to it, or is it going to become a nothing burger? We will see. And also TJM with another super chat. Thank you. What do they call lazy kangaroos? A pouch potato. I absolutely love that. Thank you for that. Alrighty, back on to the testimony here.
are you aware that this particular bag, that bag that contained those 6 items of plastic material that you already deemed was incredibly important to the investigation, was never booked into any evidence until March 14th, the date that it was submitted to the crime lab?
I was not aware of that, no.
We can take that down, please. If I may approach, Your Honor?
Yes.
Thank you, sir.
You're welcome.
Did you ever draft a report yourself documenting the recovery of those 6 items and the other 14 items that you said that you found on the same date, February 10th?
I did not, no.
Did you leave that assuming that Trooper Proctor would document that?
Objection.
Sustained. Ask it differently.
I'll ask it another way if I can. Did you believe that you didn't need to write a report, Sergeant, because Trooper Proctor would take care of that?
I knew that it would be documented. It was already documented on the actual bag as far as who collected it, when, where, what it was, and a report eventually would be authored on it.
But the where, for all these very intricate pieces, the where is left to 34 Fairview on the back, correct?
Objection.
I'll allow it.
Is that right?
The general vicinity location of the other items collected and documented with photographs was consistent with the same locations this was collected.
Also, really quick, Alex025, thanks so much for the super chat. I hope when Trooper Proctor does show up that they play the NFL theme. That would be great. Or like I was almost thinking like, you know, the sound of the horn blaring, the one that reminds me of Jersey Shore. I can't mimic it right now, but I hope you know what I mean.
I want to shift gears for just a second. Well, actually, I want to ask one final question about that item. Based on the documentation that you just mentioned, that it's documented on the bag, and if the bag is presented to the crime lab on on March 14th, some 5 weeks later, those items were completely unaccounted for from a log standpoint for the entire time from when they were collected until they were booked at the crime lab, correct?
Objection.
Sustained. Ask it differently.
Possession of those items for those 4, 5, 6 weeks.
Are you talking about the items that were just displayed on the screen?
I am, sir.
I did not.
Now I'd like to shift gears to a ring video that you saw yesterday. It's in Exhibit 6, video number 153. That may mean nothing to you. It's the 5:07 a.m. video of Miss Reed's car pulling out of the One Meadows garage. Do you remember that video?
I do.
Okay. You indicated yesterday on questioning, under questioning by Mr. Lally, that Miss Reed's car came in contact with or close to coming in contact with the other vehicle, the Traverse, in the video. Is that right?
The video, as I watched the video, I observed the vehicle come near Mr. O'Keefe's car.
Okay, that's what I want to talk about. With the court's permission, may we play that video one more time?
Okay.
If you can pull that up, and then I'm going to ask you to pause it and get out of the way. Okay. Can you just play that for a quick second, and then I'll ask you to pause it. Pause. Does that appear to be, I'm just pausing it in the first 2 or 3 seconds, does that appear to be the video that you saw yesterday?
It appears that way, yes.
Okay. Mr. Bates, if you could enlarge the area around the the left rear tire of the Traverse. I'm going to ask you, sir, if you'll pay close attention to what's been zoomed. And when the SUV gets close to it, I'm going to pause it and ask you another question. Go ahead.
He's going to point out some movement in that tire.
Your Honor, I'm going to object to this.
So why don't we pause the screen, take it down, and I'll see you at sidebar.
All right. Going in for a sidebar. We're going to fast forward the sidebar. So the reason why he's objecting to this is because, and actually, you know what? There was a question earlier about objections to evidence. Let's see if I can find it in time before they come back. Here we go. Desiree Bula, Legalbytes question: what are some reasons an attorney on either side may object to evidence presented in court? So with something like this, with video evidence, the fact that they want to present the video evidence zoomed in, anytime it's zoomed in or slowed down or things like that, there's going to be an objection from the other side because they don't want it to be manipulated so that it is presented in a way that a normal human being would perceive these things in real time. This is very common, for example, in like self-defense cases where there's video surveillance footage. This was something that came up in the Rittenhouse trial quite a bit as well, where there was video of one of the times that he ended up shooting someone, and the prosecution wanted to slow down the moment to show this happened, then that happened, then this happened, then that happened. But the problem with showing it slowed down like that is that the person, the defendant in question, who were analyzing what his thought process was in the moment, he's going to be reacting to things in real time, not slowed down. So if the jury views it slowed down, that can improperly manipulate the evidence so that their perception of it is like they take in the information slowed down, but the defendant had viewed it in real time. It's different speeds of processing. It can give you a different perception of what was reasonable in that moment. So like there are things like that that can come into play when you're presenting evidence of like video surveillance or photos or things like that that can make things look different than what they would have or should have to a person in real time. So that's one example of why something would be objected to in terms of bringing in evidence. There also can be, sometimes with physical evidence, if something has been doctored or manipulated in somehow that it then looks different when presented to a jury in the courtroom as opposed to how it looked in real time. There are objections that could be made that at the very least would result in some kind of an instruction to the jury of like, this isn't how this looked at that time. This is what has happened in between or what have you, or, there will be testimony as to what happened in between, to sort of like clarify some things for the jury and sort of, like reframe certain aspects of it so that they can know what to look for, if that makes any kind of a sense. That's just a couple examples. There are other reasons why evidence might be objected to. Maybe it wasn't presented to the other side in time. There are a number of other things as well. All right.
Out of the way.
Oops.
I'm going to try to situate myself where I'm out of the way. If we can have the lights dim, Your Honor.
Sure.
Thank you. Okay, go ahead and enlarge the rear area of the traverse. And I'm going to ask you to pay special attention to that wheel.
So the defense won on this objection. The prosecution, that's probably the basis of their objection here, because it was once it was zoomed in that the prosecution was like, I want to objection. And the judge was like, see me at sidebar. And so, but now that they're proceeding with the zoom in, it looks like the defense won on this particular objection, which means that the judge was like, this isn't manipulating this improperly, for purposes of giving the jury, this information.
That you may or may not see.
Okay, so is that tire going to move? Is it going to bumpity bump?
Okay. In about the next 3 seconds, Sergeant, I'm asking you to pay special attention to the wheel. Go ahead.
Yep. Yes. There it is. You do see that shift forward, that it looks like it did in fact bump. So we do have contact between these two vehicles from at least from looking at that particular tire. And here's the thing too, is that the defense is so much better than the prosecution at this particular thing. There are a number of things that I think that they're better than the prosecution at. I'm sorry. I don't mean to keep trashing Lally here, because he's doing this whole thing kind of by himself, it seems like. He's been directing all of these witnesses. But here's the thing. When you are showing this kind of video surveillance footage, when you're showing photo after photo after photo, it's helpful to have the attorney that is that is showing these things to the jury through the witness to give these kinds of instructions, like pay attention to this particular thing. Look at this thing. I'm going to, in a minute, I'm going to ask you about this particular portion. And Lally has done that a little bit. Yesterday, at the very end of the day, there was that waterfall footage where he was like, look at the upper right-hand corner of the screen. I still didn't see anything there personally, but maybe someone else did. Maybe I missed it. But this is a perfect example of, like, I really want you to focus on this one thing so that the jury knows exactly where to look so that they don't miss this particular detail that is important to the defense. So this is just an example of, like, this is how you do it. This is how you show this kind of evidence so that the jury is able to gather these details and continue to be taking these points that you're putting up on the board.
We can have the lights on. And you can take that down. Sergeant, were you able to see that video? I know it's not the clearest thing in the world. Were you able to see that video okay?
Yes,
What
I
did
did.
you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling, it appears that there is movement, but the video speaks for itself.
What would you assess based on the movement of the rear wheel of the Traverse about whether or not the two vehicles came in contact with one another?
Objection.
Sustained.
That's fine. He doesn't need to
Okay.
answer that.
Um,
He doesn't even need to answer that because the jury just saw it. And he also did. He just agreed. He's like, yeah, it looks like there's movement on the wheel. The jury is reasonable enough that they can put two and two together to show that, I mean, the wheel's not just going to move on its own, right? It's going to move because the car has been moved somehow. It's been bumpity bumped. There wasn't some kind of an earthquake or something that happened, So he doesn't even need to have him actually conclude or make a conclusion as to why that happened, right? Because also that sort of a conclusion is an opinion that would be calling for speculation from him. He's not an expert, but like I said, it doesn't matter. It's just the power of that question is in the question itself, putting that in the jury's mind of, like, yes, of course, we know exactly why that tire moved. It's because there was contact between these two cars.
May I have just a moment, Your Honor?
Yes.
May I inquire?
Yes.
Thank you. I'm trying to use my time wisely, Your Honor. Yesterday, Sergeant, you were asked about a couple of videos related to the Sallyport garage. Do you have that in mind?
Ooh. Is he going to get into
Yes.
the mirror
Matter of fact,
image?
we watched one of them pretty specifically toward the end of the day yesterday. Did you actually, I want to talk about the one that is the clearer of the two where you slip. You remember that one?
If you pull it up, I can.
I will in just a second.
Okay.
There was one where Mr. Lally paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was icy that day. So if there's documentation of me slipping, I might have happened.
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos.
I actually didn't notice.
It's Exhibit
that
446, but I don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to Canton PD to retrieve any or all of the videos of the Sallyport? You yourself?
Probably not.
I did go to Canton and collect already extracted video,
Okay.
but it was a portion of video surveillance. I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect a portion of the video?
I don't remember.
Okay.
I don't remember. I'm sorry.
Did you review well, let me ask it this way. Did you collect a video that was sought on or about April 23rd, April 24th of this year, meaning just a few weeks ago?
Did I collect it?
Correct.
I did not collect that video of April this year, no.
You're aware that the video that you saw yesterday was in fact collected after the trial started in April of 2024?
Objection.
Sustained.
Yeah. So
Are you aware of when that video that we saw yesterday was collected?
Objection.
I am not aware.
Okay. Was yesterday the first time you'd seen that video?
No,
When had you seen that video previously?
a couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
Sustained.
Did you have a meeting with the DA?
Objection.
Sustained.
Did you ever have any kind of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yes.
okay. So this kind of information about like the litigation, what got handed over from the prosecution to the defense, et cetera, that's generally not going to be allowed in front of the jury. Because it's just that's the kind of stuff that's just tends to be more prejudicial rather than probative. And so it usually is not introduced to
Did you have any meetings?
Oh, sorry.
May I?
Yes.
Thank you. Sergeant, did you have any meetings or communications with Mr. Lally in anticipation of your testimony?
Yes,
When was that?
it was about 2 weeks ago, and then last week, I believe.
And what was discussed generally?
Generally, we discussed the portions of the case that I would be presenting.
Did you write a report about your communications with Mr. Lally?
No, I did not.
Were you shown any of the videos that you've seen here in anticipation of your testimony?
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Sally Port that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so I don't remember exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You have seen that one before,
Yes,
and that was with Mr. Lally, correct?
that is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that Exhibit 446 for a second, and then I'll show it to you.
So Jackson's trying to get this information somehow in front of the jury that this is new footage. People haven't really looked at this or seen it or sent it over to the defense, maybe even. And maybe the jury's going to pick up what he's putting down, but maybe not. So, so one reason why he can't really testify about what the litigation, the how the sausage is made, so to speak, behind the scenes in the pretrial litigation is because this witness doesn't really know, right? He doesn't necessarily have personal knowledge about what's been going on between defense and prosecution in terms of like evidence production and things like that. So that's one reason. So, he's got to keep it tailored to when did you know about this? When did you discuss this with the prosecutor? Did you take any notes? Because that kind of stuff, he's asking about notes because that would be discoverable. The defense would then be able to ask the prosecution for any kind of notes that were taken during these kinds of meetings because that's not confidential. Their discussion with witnesses about their testimony in advance. So then asking about like, well, the video footage that you saw on this second visit with the prosecution, did that include this interior video of the Sally Port? I don't know. I don't really remember. I don't know. Cross-examination, maybe. I don't know. Maybe cross-examination, maybe it's legitimate that he just doesn't remember. To be fair, there were a number of video surveillance pieces that he testified about yesterday on direct examination. So, maybe they kind of got blurred in between. Maybe, I don't know. Folks can agree or disagree on that particular point. But Jackson's still trying to like pull this out and put it in front of the jury that there's something weird going on about this particular video.
You indicated that the video all the videos, everything that you saw yesterday was true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place in accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to.
He's laying the foundation. I think he's going to point out that it was mirrored. So this is going to be interesting. He's like, this is all accurate, right? All super accurate, right? Okay.
Find out. And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear tail light in any fashion? And you said never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, or touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion of the vehicle, right? That right rear tail light.
The right rear damaged taillight, correct.
Right. With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
Before we begin playing it, Mr. Bates, if you wouldn't mind, may I inquire, Your Honor, of the witness, just to lay a foundation? Sergeant, do you recognize this as being the video that we saw yesterday?
It does look accurate.
Okay.
Yes.
I just wanted to make sure we're on the same page. This is 446, just so you have it in mind if I reference that. Space, if you could play that.
I think he's gonna lay the trap. He's gonna have him say, "Yep, look at that portion right there. That is the right rear tail light. You can see that we never touch it. As you can very clearly see, we never touch that." And then Jackson's probably gonna point out right afterwards, "Look at that backwards 4. Look at the backwards police that's on the back of this old cruiser. This is going to be interesting." And then have him like go over it again, perhaps. This is going to be very interesting to watch. I'm ready for an expert Jackson cross-examination right now.
And I think it's runtime 120.
So really quick, the question, what do they gain from this? Mike Wilson, I see that in the chat. The reason is because, so he just pointed out that, on direct examination, you testified that this video shows that neither you nor Trooper Michael Proctor touched that area of the right rear bumper of this vehicle, right? Where that taillight is. Neither of you touched it. You didn't manipulate it. That's what this video surveillance shows, right? So he's like, yes. So the reason why it's going to show when he's going to point out when it's mirror image is he's going to say, well, actually, look at the other side, because everybody's looking at what looks like the right rear taillight, but look at the other side. That's the left rear taillight from this image, because that actually is the right side. It's flipped. It's mirror imaged. So this doesn't show what you say it shows. In fact, maybe it actually shows that he did in fact touch it, or he was in the area with opportunity to have touched it, to have manipulated it. We're gonna see where he goes with this, but I think that's where he's gonna go. Okay.
Do you recognize that as the video we saw yesterday?
Yes, I do.
Very briefly, if you could move to time of day, 5:37:05.
All right, they're reversing. Oh, I wonder if he's going to go back to show someone getting out of the driver's seat.
Yes. With the court's permission, can we play at this point?
Yes.
All right, that shows the vehicle coming into the Sally Port, and we're looking at which side of the vehicle?
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle. I do not know why it is inverted, but that's the way it was presented, collected and presented from Canton Police.
Can you see a timestamp?
Interesting here that he volunteers that information, because he didn't volunteer that yesterday on direct examination. But it's almost like Bukhenik was like, "Yep, I see where you're going with this. I'm going to volunteer this so that it doesn't look like I get caught with my pants down," so to speak, metaphorically speaking.
Stamp or time and date stamp on the bottom of that. It's in blue.
I cannot know.
Okay. Does it appear that time and date stamp, if you can't read every letter on it, that is in correct order? In other words, that's not inverted.
I cannot read it, no.
All right, let's go ahead and play this for a second.
It was inverted.
Who is that just got out of the car?
I do not know. I think that's the tow truck driver. He would have the only access to the vehicle. We did not touch the vehicle.
Who's that on the left?
I missed that. I was looking down at the laser pointer. I do not know. I know for a fact I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
Back up. That was playing, and I didn't realize it was playing while you were talking.
Let's go back. Reverse.
And stop. Yesterday, when you testified, you indicated that the two individuals in this scene were you and Trooper Proctor, correct?
Not correct. There was two individuals in the rear of the vehicle. I shined my light to. That was me and Trooper Proctor.
Do you see Trooper Proctor toward the back of the rear of the vehicle there?
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
That's fair.
This
It's
person in
just a
that,
silhouette at this point.
In the video to the left, to the rear of the car, is wearing a black hat, correct?
I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically.
That's fair.
I can't testify to that.
There's no magic about this. It's your testimony. I'm just asking you what you see.
I don't see that. No.
Let's go ahead and play at this point.
Okay.
You see the person toward the back of the vehicle walking toward the opposite side of the SUV?
I do.
What area does he appear to be going to?
He appears to be going towards the rear passenger side of the vehicle, although it does not appear so because the video is inverted, a mirror image. That's where he's going.
And Sergeant Bukhenik, you testified for at least a half an hour about this video yesterday, correct?
I'm sorry, it was a long day. I don't know the timing of how long I testified.
You significantly testified
That's fair.
about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Correct.
And you testified that it was it was reflective of your observations of what was happening in that Sally Port that evening, correct?
I testified that this is a accurate scene and collection of video evidence from the Sally Port.
And as that truck sits in that Sally Port, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
Yeah.
I'm sorry, can you repeat the question?
From this perspective, from the perspective that the jurors are looking at,
Okay.
from all indications, that would appear to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your question
Yeah.
by Mr. Lally, not once did you mention that this video is actually completely inverted.
Yep.
I did not know.
Mr. Lally,
Yes. Okay. So here's, I mean, well, first, first things first.
Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
Yeah. Okay. So yeah, this is hella suspicious. This is really suspicious because here's the thing. So Bukhenik helped himself quite a bit by being the one to volunteer this information on cross-examination without being forced to do so by Alan Jackson. That was very smart of him, very savvy of him. However, the fact that he didn't volunteer that on direct examination when they were spending all this time showing what we thought was the passenger side, the right rear taillight, and examining that for like, oh, okay, well, no, it looks like nobody touched that side. Everyone's focused on that one corner. Meanwhile, that's the wrong corner to be focusing on. The fact that no one volunteered that on direct examination, it looks like maybe Officer Bukhenik was pulling a fast one, because this is now the second time that he's testified on cross-examination, or he's given an answer on cross-examination that has revealed something along the lines of like, well, you didn't exactly ask me the right question, so I didn't exactly give all of the information that would have been helpful to the jury. It's like it technically is correct. It's an answer that is technically correct. However, it has a flavor of dishonesty to it because he wasn't fully forthcoming with his testimony. You're still supposed to tell the truth, the whole truth, and nothing but the truth. The whole truth is part of that, right? And so, yes, there is gamesmanship in cross-examination. Yes, there is, the cross-examining attorney is supposed to ask the correct questions. And same thing with on direct examination, right? You're supposed to ask the right questions. You're supposed to ask good questions. You're supposed to ask questions that are going to be eliciting the correct answers and the answers that you want and that you need. But when it now feels like this is the second time that this witness has been revealed to be like, well, you didn't exactly ask me for that information, so I didn't want to supply it. And this is very material information for the jury to know, for them to be focusing on this particular portion of this vehicle. That's a huge problem. And it looks like he was being dishonest, and it looks like Lally was being dishonest. It looks like he's trying to pull a fast one over the jury to present this as if it looks like we were debating in yesterday, not debating, but we were going back and forth in the chat and on stream, about whether or not this was mirror imaged yesterday. Everyone was kind of analyzing this all over social media, like, isn't it? And people kind of had to dig in order for that to appear that way. The jury may or may not have noticed this yesterday. And so if they had been kind of tipped off of like, wait a minute, and then have that brought up to them, they may have been like, okay, that's what I thought. But if none of them noticed this yesterday, and then all of a sudden this is pointed out that like, oh, by the way, you were looking at the completely wrong part of the car because, oh, ha, 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 no one pointed out that this was mirror imaged. Like they're going to look at that most likely and say, y'all are lying to me. What the, like WTF here? So this is a problem for them to be able to trust this witness and to be able to trust Adam Lally here, because he's putting evidence in front of them and just not mentioning that this is completely inverted, like they would say in Top Gun. So this is this is a problem. This is a problem for the prosecution here, and this is a big point for the defense. Once again, it feels like we're not getting the full story on direct examination. We're having to wait until cross-examination to actually get material information so that we can properly analyze this case. This has happened time and time again in this trial. And that's a problem for the prosecution. Just because, thanks so much for the super chat. Lally and Bukhenik failed to tell the whole truth. That is how it feels, right? That is how it feels. So this is like, yeah, this is an issue. This is an issue for being able to trust the prosecution. And the thing is, both sides, both sides are, sorry, I'm trying to save that one for a question for a minute. Both sides from the very beginning of this trial are having to prove certain things to the jury so that they can earn the trust of the jury. Trust from a jury is not given. It's not, what should I say? It's not given, it's earned, right? So both sides have to prove time and again throughout this trial that the jury can trust them and can trust that what they are giving to them is the actual accurate version of what actually happened here. And this is a problem. This is a problem for the prosecution. Whew. Okay, let's continue.
I didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected.
Yep.
Correct?
Objection.
Sustained.
Doesn't matter, because we know the answer to that question. Yeah, if he hadn't said anything about it, the jury would have totally been thinking, yeah, well, obviously this is the way that things look, and anyway, yeah, yes.
The person with the winter cap appears to walk directly to the what ultimately should be the right rear tail light of his car, correct?
That's the vicinity, yes. That's where he is. Yeah.
Pause it. I'd like you to pay attention to the right rear of this car. And I know we're completely backward, but it's the far corner of the car. Do you see a person's head there?
It appears as if someone's still there.
And that person is located at or near what portion of the car?
In real life or as it's depicted?
Is the person in real life, near the right rear tail light of the car?
Sir, we only care about real life. We don't care about imaginary mirror imaged upside down world stuff.
Yes.
Matter of fact, standing there hovering around them, correct?
We don't know the distance that they are in proximity to the actual vehicle. We just know that they're behind the vehicle. That
Looks like it's pretty close, doesn't it, Sergeant?
Objection.
Sustained.
Does that look like he's in close proximity to the right rear tail light?
As I said, I can't tell how far away he is from the vehicle.
His head's right there, sir. You can't tell that he's right next to the right rear tail light?
Objection.
Sustained.
So that was sustained because it's argumentative. But here's the thing now. Because of the fact that this whole mirror imaged bit of this footage was not brought up on direct examination, it was only brought up on cross-examination, all of that stuff that I just said about trust means that the jury is potentially primed to look at what Jackson is saying right here and trust what he's saying over trusting what the witness is saying about the distance of this person who's actually right by the broken taillight, right? Or the taillight in question, I should say. So that's the issue here, is when there is evidence that is potentially questionable, there's a gray area between the two sides. Who is the jury going to trust? That's where this kind of stuff really matters. That's where it matters to be the one that is bringing the real truth, right? The real story to the jury, because if they are consistently getting the full story or the fuller story from your side, that means they're going to trust you more. They're more likely, so not they will, but they are more likely to trust you when there's this sort of a gray area. And right here, this is an example of that. There's a gray area as to how far is that person actually from the passenger side taillight that's on the opposite side of where this camera is. We can't really tell because that actual taillight is obfuscated. It is admittedly difficult to say. Bukhenik saying, I don't really know. He's probably actually being honest in that right now, that he's like, I'm not really sure how far this guy is. But Jackson is fully within reasonable territory to be like, really? You don't know? You can't tell? Why should anybody trust what you have to say? So this is just where where all of that really comes into play and can actually make a big difference.
I want you to pay attention to what that person does as soon as the other person comes out from behind that car. See if you see him move. Stop it. Do you see that person move?
I saw movement in the frame, yes.
Right when the other person is in eyesight of the person toward the right rear, correct?
I mean, the video speaks for itself.
Yeah, it does.
No.
Objection, Your Honor.
The objection sustained. No commenting, Mr. Jackson. We've talked about that.
That's argumentative.
Ask Mr. Bates to back it up, because there's one other issue I want you to pay attention to, if you can, right at this moment or right before this moment, and that is the timestamp. We back it up in maybe 10 seconds. Right about there. Don't play it yet. Instead of paying attention to the individuals, I'm going to ask you, can you see, may I approach the screen, Your Honor?
Yes.
Can you see the timestamp at 5:37 and 37 seconds p.m.? Can you see that from where you're at?
No, I cannot.
Me neither. That's why I don't walk up to it. Let's play it for about 10 seconds. Pause it. Did you see another person just appear toward the rear end of the car?
There was a fog of some sorts. It did appear as if.
Sorry, I'm going to go back because I was taking notes when that happened. I apologize, guys. Okay, so this is okay. Aha.
Pause it.
There's a time jump.
Did you see another person just appear toward the rear end of the car?
There was a fog of some sorts. It did appear as if a person was actually in. There was two people back there, and two people walked away, or one person walked away.
The timestamp jumped to 5:38:01. Correct?
I cannot see the timestamp, sir.
Okay. Did it appear that there was an anomaly? There was a portion of that video that was deleted. Or it's missing. Not deleted, but just missing.
Objection.
Can you tell that? Does it appear that way to you, Sergeant?
No, Your Honor, I cannot tell what is happening with the video.
So he can testify to that. The jury can take note of it, and when they are going to deliberation, jury can take a closer look at a lot of this stuff. And so they may want to take a look at this video and look at these timestamps and be like, okay, let's take a look to see, is there really a jump? who is this over here? These are details that I'm sure that the defense is going to be hammering on closing argument. Like it's super important to their case right now to show, whether or not there may have been some manipulation of this vehicle while it's in the Sally port. And so even if the jury doesn't see those timestamps shifting right now, they should have opportunity later on to be able to actually see it.
If you take a close look at there's a classic police car in that Sally port, correct?
There's an antique vehicle there. Yes, yes.
If you take a close look at the trunk of that vehicle, see the word police?
Yes, I believe I can read that. Yes.
And it's backward, correct?
It is mirrored, correct.
That's a good indication that this is an inverted video, right?
It appears that way, yes.
And if we were to fast forward at 5:42, not another 20 seconds. There you go. Can you just play it at this point? No. You take one and pause it. Pause it. You see the Sally Port garage came down?
Yes,
You see a number on the garage?
4.
I do.
Is that correct?
It's backwards 4.
What is correct?
Does the number appear correct? How do you make it 4?
No, the number's in the mirror image, yes.
I just wanted to make the point. Everything in this video is completely backward, correct?
It's not backwards, it's mirrored, reversed. You can look yourself in the mirror in the morning, you still see your own face. It's not backwards.
Okay. All right.
But my
Dean.
mirror image is not an accurate depiction of who I am. My
Check.
actual physical appearance is who I am, correct?
Objection.
Sustained.
A mirror image, Sergeant.
So like we may be getting into some more theoretical, territory here with this portion of the testimony, but Jackson is making a point. Technically, accurate versus accurate, different versions of accurate. Okay, like it does depict what happened in the room, but it depicts it in reverse. So, but the jury's going to have picked up on this already.
It's not an accurate video of this, is it?
Objection.
It's a mirror image by definition.
Sustained. Ask it differently, Mr. Jackson.
Your Honor, thank you. I don't think I need to.
Yeah, he's already made the point.
I would like to mark I have we can bring the lights up.
Let's wait.
I have a thumb drive that I'd like to have marked with the court's permission.
Okay. Does Mr. Lally know what's on this thumb drive without you telling us?
I do not.
Okay.
We can approach and I can certainly bring it up.
We're trying to wrap up our morning.
It's,
It's marked for identification.
if I may, Your Honor, I'd like to play the first 10 seconds of that video.
No. We'll come to sidebar. It's marked for identification.
All right, sidebar. Is this where we end early for the day? I think someone in the chat mentioned that the testimony ended early for the day. Let's see. Yeah, it looks like we are making leaps and bounds towards the end here. Yeah.
I know that you want to know when this case is going to end, and I don't mean that in any negative way.
Your Honor, we all would like to know.
After speaking with the lawyers, I can
safely say that you will get this case for your deliberations sometime the last week in June.
Ooh.
We'll know better next week. We will not be in session next Tuesday. We will go full days, Monday, Wednesday, Thursday, Friday next week. We will not be in session next Tuesday. All right, I have to give you those cautions again. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. It's a great weekend. We'll see you Monday.
Okay.
All rise for the jury, please, jury.
You are muted.
All right. So let's see if there's going to be anything else between, or is everybody just packing up?
Oh,
And
I
moving?
on my
Oops, sorry.
motion.
Okay.
All right, so I received a motion from the Commonwealth this morning that I have not had an opportunity to read yet. It's on my desk. I'd like to go spend a few minutes looking at that and come back out at 12 o'clock on that.
In order for us to argue it?
Yes. Do you need?
I haven't looked at it either.
Okay.
We've been busy.
All right.
Could we do it on Monday?
I want to get as much evidence in as we can each day. We can do it at 8:30 Monday morning, I think. Madam Court Reporter, can we do it at 8:30? Yeah, Jim?
Sure. Absolutely fine with us. Not that it matters. But
Can we do it at 8:30 Monday morning?
If that's what the court wants, yes.
Yeah, we'll have a hearing on it at 8:30 Monday. Are you around tomorrow? Are you around tomorrow?
Oh, am I? Yes, absolutely.
Do you want to do it tomorrow morning?
If I had a preference, I would say Monday.
All right, we'll do Monday morning at 8:30.
I'm sorry. Monday 8:30. Okay, great.
And if you want to put something in writing, just email it to us this weekend.
Will do.
Okay.
Thank you.
All right, we'll see you then.
All right.
All rise for the court, please.
Okay. So that is the end of this one. The fan goes spinny, spinny. We're going to take that off screen. Okay. So we've got a lot of questions to answer, but first, the schedule for next week. We now have a schedule. So Monday, Wednesday, Thursday, Friday are all full days next week. There is no trial on Tuesday. For me personally, I am still on the West Coast this next week. However, Friday, I am traveling. I am on a plane. I will not be able to stream that day. And that's a full day of testimony. I'm sorry, guys. I already had these flights booked. After that, though, I am back in the studio. We will be streaming with the Bytes pets. So you guys will be able to see the indie cam and all that good stuff once again. So that will be good news. However, Friday, I will not be able to stream the testimony. So I will still be getting recaps out on it. So, but Monday, Wednesday, Thursday, I will be able to stream all of those days. So, all right. Yeah. And also there's going to be a sidebar or actually, no, it seems like there's going to be a motion in limine that's going to be argued, or some kind of a motion that's going to be argued between the two sides. Maybe we will be able to see that on camera. And if that's the case, then I will, be able to stream that, and we'll watch and we'll comment on that also. Okay. So, yeah, Jessica, I do miss Indy Bear. I miss the cats too. So I will be very happy to have her back once again. All right, let's see. Let's get these questions in here. Okay. Let me just make sure that I've got these also on here. So unfortunate that we didn't get to finish that cross-examination. I was hoping that we would be able to, but let's get to this. Okay. All right. Let's get all these questions. We've got a lot because I didn't stop to answer these questions during the testimony. All right. Coming up on this. Oh, Ardo, I'm so sorry. I should have answered this at the very beginning. Question, update on Lally Tally. And a guess, do we hit 2,000 before the end? Okay, so let's see here. Let me go back to my Lally Tally over here. Okay. Let me actually bring this up on Twitter. I'll share the screen. Here we go. All right. What, if any, Lally Tally going into day 21? Total after day 19 was 1293. On day 20, there were 126 what, if any's. 126, y'all, on a single day. Grand total is now 1,419. So, yeah, are we going to hit 2,000? I think so, especially if this trial is going to go until the end of June. It definitely seems like it to me. So, all right. So that's the Lally Tally. For sure, we made progress on that today as well. We heard a lot of what, if any's today. Mike Olson, something that Lally didn't want the case. We know he wanted to delay it anyway, but was more or less forced, and therefore he is botching it, at least not do his best, or at least he's not doing his best. Thoughts? I don't necessarily want to conclude that, because that would violate the rules of professional responsibility. Every attorney, regardless of how much you believe in a particular case, you have a responsibility, a duty to zealously advocate for your client, and that is the Commonwealth in this particular case. So, if he's trying to throw the case, that's not good. That's not good. That's not what an attorney is supposed to be doing, regardless of how you feel about the merits of your particular case. Let me also end this poll while we are at it, because otherwise I always forget. So going into day 21, which way do you lean regarding KR's murder charge? 75% said not guilty, 17% said need more information, 6% said guilty, and this is 1,300 votes. So, all right. That's where it's at still. Jerry Roth, what's the point of co-counsel if Lally does everything himself? What's the point of him having co-counsel then? So this is the what we see is Lally doing all the work. However, there is a lot of background stuff. So for example, if there's an impeachment that needs to happen, having co-counsel, having a second chair, even if they're not the one getting up and speaking, having them be there with an assist with, like, these are the documents, these are the exact places that you need to look for this impeachment, or for this point on cross-examination, or for this particular point on redirect, to respond to certain things. Having that co-counsel there to help out with like that kind of documentation, etc., is particularly helpful, so that you don't have to be wasting time kind of like trying to stumble through these sort of moments. We saw a bit of that in the Rust Armorer trial, the Hannah Gutierrez Reed trial, when Bowles is his name, when the defense attorney was kind of fumbling through certain impeachments and other aspects of the trial. It would have been helpful if he had someone there to just sort of be that assist, to like supply him directly with certain things. We saw that done in a very spectacular way during the Depp trial. Depp's team was very good at being there with like the binders and everything, just supplying that right to the person who needed to make the point. So there's also that help as well. That may not be particularly obvious to the casual observer. Megan Weber, question, if someone pleads the fifth on the stand, doesn't that get every part of their testimony thrown out? If they won't answer every question, why would any of their answers be trusted and valid? Yes, all of it would be tossed. Sarah Therese, Legalbytes, were the taillight pieces tested for DNA? Not to my knowledge. None of those were. Baz 80s, question, have they given any explanation as to why we have seen screenshots, not the extraction? Isn't that abnormal? Not necessarily. I mean, if you look at like a Celebrate extraction, it can look like a lot of data. The jury may or may not know necessarily like what to look at, what should stick out to them. So, it's not crazy to me that what they've seen is the pieces that have been identified as most important for that. Baz 80s, question, would she have known she was being recorded? Probably, most likely, yeah. And talking about Karen Reed during the audio portion. Sir Christopher, will Karen be called at some point? We don't know. She won't be called by the prosecution, because she has the ability to invoke her Fifth Amendment right all the way up until the end of the defense case in chief. So she has the ability to do that. The assumption is she would during the prosecution's case in chief. And so, at the end, it may be that she is the final witness for the defense case in chief, or it may be that the defense goes through all of their witnesses and then they say the defense rests, and the judge then has the defendant come up and answer some questions, basically saying, like, you understand that you have a right to testify, you also have a right not to testify, basically ensuring that she's doing all of this willingly, voluntarily, and with full knowledge of the repercussions of what it is that she's deciding, whether to testify or whether to not testify. Tammy Fayette became a new YouTube member. Welcome to Byte Club. Very happy to have you here. Hopefully you can join us tomorrow at 10 a.m. East Coast time for our members only live stream. Welcome. Is it Langy or Langy? I'm sorry. I'm sure I butchered that. When are we getting the trial recaps for days 19, 20, and 21? Thank you so much for asking that. I've been working with my editor, who I said at the beginning of the stream, my editor got kind of sick. So there is a backlog on these recaps. I appreciate everybody's patience on that. While we get those out, day 19 hopefully will be out today, but completely depending on, I don't want to rush my editor if he's not feeling well. But depending on that, those will be coming out as soon as possible. The day 20 recap has also been recorded and just needs to be edited and put out. Day 21 will be recorded today. So we'll be getting those out as soon as possible, but without rushing anyone, because I don't want to be that kind of person to harp on somebody who's not feeling well. Also, thank you for the super chat, Mr. W. Guilty or not guilty of the counts in your opinion? I think that, in my opinion, I say still at this point, there's too much reasonable doubt to convict. In other words, not guilty. So that's my thought so far. Debbie Faison Cook, Legalbytes, how are you pregnant sitting in Catalina, California in June wearing a sweater? Do you have the AC turned all the way up? So that's something about Southern California, is there's this thing called June gloom. So, whether I'm on Catalina or on the mainland, if you're on a coastline in the morning, there is a lot of, it's very overcast. There's a lot of cloud cover. And so that really brings down the temperature. It kind of brings in some humidity, but it's like a cool humidity. So this kind of like sweaters and things like that is like most comfortable in the mornings and in the evenings. It burns off around noon and becomes sunny. But I mean, it's like the high here on Catalina is like 70 degrees right now. So, well, not right now, but will be like later on today. So, it's sweater weather. Triker question, how does hostile witness work? Like in real life, at what point is it appropriate to treat someone as a hostile witness? And then also related to this, Draco Amy, can you explain hostile witness again? We have questions. So default for any cross-examination is the witness that you are cross-examining is hostile to your witness. So it's not a hostile witness is not like a description in the sense that we commonly think of someone as hostile, right? Like you walk down the street, somebody punches you in the face, that's somebody being hostile, obviously, right? Or, somebody just being like unnecessarily argumentative, with someone that they either know or don't know. That's not the kind of hostility that we're talking about. What we mean in a court setting when somebody is a hostile witness, that means that they have an opposing interest from the person who is asking them questions. And so, like I said, by default, by definition, a cross-examination is generally always going to be a situation where you are questioning a hostile witness because they're hostile to your interests. Now, if you are calling someone who is, you're the one that's calling them. However, that they have interests that are more aligned with the other side. You can call them, have them declared as a hostile witness. And then therefore you can ask them leading questions as if you are cross-examining them, even though you are the one to call them. And technically it's a direct examination, but that is where, you kind of have to make an argument for it. You've got to make a case for it. And maybe that's done in advance. Maybe that's done in the courtroom, probably outside the presence of the jury, because that could confuse the jury and whatnot. But But anyway, you have that determination made, and then you can do that. So that's where that comes from. So this question comes up in the context of Trooper Proctor. If he's not called by the prosecution, that means that the defense can still call him, and he would be a witness who is hostile to the interests of Karen Read. So therefore, they probably would be able to cross-examine him in a direct examination. This can be advantageous to the side that is calling the hostile witness, because remember, on cross-examination, you're asking leading questions. You're able to put them on a very tight leash and just basically, in a sense, like the best cross-examinations, in my opinion, are the ones where the attorney is asking such sharp questions where the witness is essentially being used as like a hand puppet for the defense's narrative, right? Like, you're the one as the attorney that is testifying, but you're using the testimony of the witness on cross-examination to put your narrative in front of the jury. So you're kind of using them, like I said, as a puppet. So you can do that in a direct examination. That can be very powerful. It can be very challenging because, like I said, they are hostile to your interests, but it can also be very powerful if you can do it well. And I fully anticipate that these attorneys are very capable of doing it well. Right. Also, Tammy Fayette, thanks so much for the super chat. I'm sorry I hadn't seen you in a while. Didn't know you're pregnant. Congrats. How far along? Thank you. Yeah, I know it's something that has occasionally come up. I don't talk about it, every day, but yeah, I'm due in September. So I am a ways there. Definitely feeling baby bites kicking. And moving on, maybe in some senses hurtling towards motherhood. So thank you so much for the well wishes. Janet G, from what I recall, Canton PD is a very small PD. Wasn't it said this was their first crime scene that they had to process? I could be wrong. One of the witnesses did testify that they typically don't process their own crime scenes. They typically don't gather evidence for their own, and that was why they made these decisions, like gathering blood in unsanitized red Solo cups and use Stop and Shop bags and things like that. Yeah, it is interesting, but that doesn't necessarily mean that they don't house evidence at Canton PD station. I don't know. Maybe there's a distinction there, but will the jury see that distinction? I don't know. They may be asking that same question that you are. Ikis question, or maybe not question, Legalbytes, with the judge saying ask another way, she's not helping or coaching out the person during the question. I mean, she has done this for both sides. So it's the same sort of response as when a judge says, sustained as to that objection. When somebody objects to, in a particular way, usually they give the basis, right? Typically, in most cases they do, not in this case. But, if somebody objects and says, objection leading, then the judge may say sustained as to that objection. That's a hint. That's a hint to the attorney to say, you can ask another way. But here she's actually saying, ask another way. And that's not improper, especially she's saying it to both sides. She's basically saying, the way that you asked it was problematic, but this testimony isn't necessarily an issue to be brought in front of the jury. So just, follow the proper evidentiary rules. Don't be argumentative, or don't be leading if you're on direct examination. So that's in my opinion, I don't see any issue with that, especially since she's been saying it to both sides. Baz 80s question. Also, can the defense play the video zoomed in to see the taillight when KR drives away? Yes, that was something that they could have done. They were able to show that with the tires. So there's nothing telling me that it would have been improper for them to show it with, after all, the prosecution did show the freeze frame of that moment to show the tail light. For whatever reason, the defense decided to skip over that portion of the ring footage, and that's their decision, in terms of their strategy. Scottish Jason question: Marine Corps drinking bottle Yuriy has in order to influence jury. Is Yuriy influencing the jury? That's another question. Probably, right? Any references to, his long reference in his long bit of testimony about his background having served in the Marines and what he did in the Marines and all that kind of stuff. There are like two explanations for going into that. Obviously, there's, it helps to give his background in terms of his investigation, and there are overlaps between service in the military and service, in the police force, or there can be anyway. So there is good purpose for giving that kind of background, but obviously from the excuse me, I'm talking too fast. From the prosecution's perspective, there's also this, this added benefit of when military is referenced, particularly in some jurisdictions. Some may not care so much. Others may care more. I would imagine, as an example, in California, the difference between Orange County and Los Angeles County, folks in Los Angeles may not care as much about military service. It's still probably beneficial, but in Orange County, where you have Camp Pendleton, the Marine base, and you've got a lot of veterans that are living, it tends to have a little bit more of a veteran/military service kind of a vibe. They're right next to each other, and people can frequent across the borders between Orange County and Los Angeles County in Southern California, but there's just a little bit of a different vibe. It might play a little bit differently in a California or in an Orange County courthouse versus a Los Angeles County courthouse, in terms of like how much that benefits someone to talk about their military service, for example. But generally speaking, overall, it is beneficial in the United States for someone to reference the fact that they have served in the military. And so he did talk about that quite a bit. And so this, the water bottle with the Marines logo, of course, that could be another subtle sort of little thing, but it's not improper. It's not improper to have that on there, especially since he already talked about it. It's kind of reasonable for to expect that somebody who served in a particular branch is going to have something like that, right? Like there's a lot of like veteran pride that does tend to carry over even when somebody does leave the military in the US. KM Legalbytes, what did Lally do with the mirror video? A common tactic. Oh, what Lally did with the mirror video? A common tactic in litigation, even if it is ethically wrong. It can be, but there's risk. There's a huge risk, right? And we saw that played out today. The risk is you can get called out by the other side and then look completely untrustworthy. If the other side really points out to the jury that you are trying to pull the wool over the jury's eyes, jury may not look very kindly on that. So, maybe the other side doesn't catch it. And then you say like, okay, well, we got away with it. But I think it really depends. It depends. I don't want to say that this is like super common in litigation, because it is a dirty tactic. It really is a dirty tactic. And I think that the better option for Lally would have been to point out to the jury on direct examination, okay, now notice police is written backwards. Notice number 4 is written backwards. What's up with that? It's mirror imaged. Okay, so let's look at the other side. You know what I mean? Like it would have been a much better practice, even if we don't necessarily look at it from an ethical standpoint, but just a best practices standpoint, because you really open yourself up to the risk that you're going to get called out by the other side, and that the jury's going to lose some faith in you, that you're being forthcoming with them. Ashley, Roman question. Any guesses on how much this defense is costing Karen? Oh, geez. These are expensive lawyers. I'll tell you that much. These are definitely expensive lawyers. And I haven't sat to calculate, but I would imagine easily multiple 6 figures, if not 7. At some point, because of the fact that this has been going on for years. There's been a lot of time that's gone into it. There's been a lot of hearings that have gone into it. There's been a lot of discovery that's been put forward. There's also been communications with the feds and, getting information from from, their grand jury hearing and all of that kind of stuff. Like there's just been a lot in this case. There's been a lot of litigation. And now, of course, in trial, this is a long, long trial. These are long hours. Plus, Jackson is flying from the West Coast to the East Coast. All of that those are costs that are generally paid by the client, plus hotel costs and, like all of that kind of stuff. So, I mean, I would say, yeah, like I said, easily multiple six figures, if not up towards 7. I can see that. I can see that happening pretty easily. Baz 80s question. Lally must have seen the timestamp and person jump in the image inversion. Isn't that just bad lawyering to bring that in as evidence and not anticipate the defense pulling it apart? We've seen this time and again. We've seen this where there are issues with a particular bit of testimony, a particular witness, a particular bit of evidence where, in hindsight, yeah, the prosecution should have seen that coming and they should have anticipated it and they should have acted in anticipation of that happening. And when they don't, it looks like either they're being lazy, they're being dishonest, or they're just, I don't know, or they're just unprepared somehow. None of those options really look good for the prosecution, in my opinion. So yeah, I don't know. I don't know what else to say about that. It just, no matter how you do it, how you slice it, it doesn't look good. Jerry Roth, Legalbytes, why does the schedule change week to week? Isn't there usually a uniform schedule set at the start of the trial? Yes. I mean, typically a trial is going to go Monday through Friday, full days. Like that's kind of the default, or during the DEP trial, it was Monday through Thursday, except for towards the end, they decided to add in Fridays just so they could get a move on that particular case. But that was like, they were like, okay, from here on out, we're doing Fridays. So people knew exactly what to expect. It is very frustrating that we can't anticipate the schedule here because it keeps changing every single week. We now have had testimony every single Friday, except for last week, even though Fridays are supposed to be testimony free. So I don't know what's up with that. That's just how things have been happening in this trial. It's very frustrating. To Major LDN, question, does confirming the jury will get it for their deliberation mean she's already decided not to grant a motion to dismiss if presented? Isn't that unfair? Ask again. Okay. So yes, thank you for doing that, because I didn't catch that before. So yeah, no, I mean, I think what she's saying is that, like, what she's basically saying here is that, this trial is going to be ending testimony by that point. The jury can still come and find out that the case has been dismissed before they get to it. And then in that case, there's really no harm, no foul, because there's no decision for them to make. It might be a bit of a letdown for them after this point of how many weeks in trial. But no, I don't see how that would influence the jury in any way, because their expectation probably at this point is, I mean, just like any jury would, is what was I going to say? That there's the expectation of the jury, generally speaking, is that they're going to be making the decision. So if that gets taken away from them later, they didn't anticipate it. That's, like I said, no harm, no foul. All right, Emma Mack, question: can they recuse themselves from just a portion of an investigation? They all had said they were recused from the interviews, but were apparently still super involved. How does that count as recusal? Jury is, maybe going to be asking the same thing. I'm asking that same question. How does that make for a proper recusal if they're only keeping themselves from interviewing people? When there are other important aspects of the investigation to include evidence gathering, evidence maintenance, and things like that. Like, there are all kinds of ways that people can mess with an investigation if they have a conflict of interest. It's just, it would seem that the appropriate response to that would be, we're hands off on this investigation, entirely hands off. And I don't know, that may have an impact on the jury. Who knows? The Lucian, Legalbytes, misclicked enter last message. Sorry. trying to read through this. Regarding the ask another way question, I think Ickes was asking if that is giving too much help to the lawyer, not so much about taking sides. Judges will do that. Judges might do that depending on their style. Some judges are just gonna say, sustained, and it's up to the lawyer to decide whether or not they want to try and ask in a different way. Other judges are gonna be much more helpful and friendly. What matters most is whether they are being biased towards one side or another. Like there's nothing saying that a judge can't throw a bone to the lawyers when they kind of need one, as in other words, to give a hint, especially if at the end of the day, what matters most is evidence being properly brought in and not being held out on a technicality when it otherwise should have been brought in. So, judges are going to care about that kind of stuff too. That to me, it doesn't bother me for the judge to be like throwing a bone to the lawyers like that, because it's more helpful to actually getting legitimate testimony in at the end of the day, if that makes sense. Let me check in just to see. I think there's at least one more question here. I want to just double check that we've got all of these in here. Bear with me for a second. Janet G. Legalbytes, speaking of cost, how is Karen going to pay for this? I don't know. I actually don't know. I know that she had, or at least my understanding is that she had a lucrative job in finance. She also was a professor. She also owned her own home. So I think that she has resources for this, but this could end up depleting all of those resources because it's expensive. Defending yourself in a criminal case is very expensive. Joshua Marshall, question: how come the shoe they found showed having a black sole in the photo, but the one in evidence has a white sole and was also changed from L to R? Interesting. The cross-examination is not finished yet, so I wonder if the defense is going to be bringing that up as well. I had missed that, so I didn't know about that. I didn't pick up on that particular detail, but I would imagine the defense probably has. So it'll be interesting to see if that comes up on cross-examination again. Moving on down. Okay, did I get that? I think there was, wait a minute. There's one that I know I missed. No, I got this one. Okay. All right. So, okay, I think that's everything. That's everything for the day. This has been a shorter day than anticipated, but I'm not going to complain about it. I won't if you guys won't. So those recaps should be coming out as soon as possible. I'll post when those are ready. And those will all be out for sure by the time we've got more testimony for you on Monday morning. So, like I said before, the schedule for this next week is Monday, Wednesday, Thursday, Friday, full days of trial on all of those, nothing on Tuesday. And like I said, I am traveling on Friday, so unfortunately I will not be able to stream that. But I will be doing a recap for it regardless. We'll cross that bridge when we get there. All right, folks. Thank you once again for joining me for this trial. Day 21 is in the books. This has been another wild day. Another great cross-examination by Alan Jackson. We'd love to see it. I love to see a good cross-examination, and we'll see where this case goes, honestly. Tammy Fayette, did I miss your super chat here? Let me see here. I see that in here. Oh, excuse me. Hang on. No, I got this one from you. Thank you so much. If you missed it, I'll read it again. Thanks for the super chat. I'm sorry I hadn't seen you in a while and didn't know you're pregnant. Congrats how far along. So, thank you so much. Very kind of you. I'm due in early September. So, I am. That's Mr. Bites. He's excited too. We are very excited. We're excited to become parents. And yes. So let's see here. TJM. Thank you for the super chat. Yeah, I guess I missed a few super chats. So thanks for the super chat here. If you were on the jury, which way you leaning? Not guilty. So far, I have not seen the prosecution prove this case beyond reasonable doubt. There is still time. They have not closed their case in chief. They haven't rested their case in chief. So there is still time for them to prove it. After all, they made some good progress yesterday on the DUI charge in particular. So maybe they'll have some late evidence and end with a bang. That's always a possibility. So I am keeping my mind open to that possibility, but so far I haven't seen it. We'll see what happens by the end. The salty Sabo. I'm sorry. I'm sure I mispronounced that. Thanks so much for the super chat. No question, just funding for coffee. Congrats, and may your pregnancy be smooth sailing. Thank you so much. I really appreciate that. Thank you. And also TJM, thanks for the super chat. Congrats on the upcoming Bite Et. Thank you. We're, like I said, we are very excited about baby bites. So, all right. There we go. And that is about it. So thank you so much once again. Thanks for all the super chats, all the memberships, and all that kind of great stuff, and all of the engagement in the chat, and of course in comments if you're watching on replay. Thank you so much. Thanks to the mods as always for helping to usher that dialogue in so folks can agree and disagree, and do so, respectfully and productively and whatnot. So as we continue to look at this case and evaluate this evidence as it comes out, I appreciate every single one of you for joining me on this crazy roller coaster ride. All right, folks. Like I said, keep an eye out for those recaps. We're going to get caught up on those as soon as possible. All right. That's about it. Thanks, guys. See you in the next one.